Ladies and gentlemen, we are happy to see you at our Congress second day English part. Today with you will be me, Kristina Borovikova. I'm organizer of Eurasian Data Protection Congress and co-founder of Russian Privacy Professional Association. And on the opening ceremony, we also have a special guest, Wojciech Wiewiórowski, European Data Protection Supervisor, and my colleague from RPPA, chairman of RPPA, Oleg Blinov. He will moderate today's section. So colleagues, you can go here with video and audio, Oleg and Wojciech. And now I want to share with you our presentation, a little promo video telling you how important Congress is for us. So yes, as you saw, it's a really big event, really great event. And also I have only 3 minutes for introduction of our partners, and just want to share with you how a lot of partners, what amount of partners were involved in this Congress. The main idea of Eurasian Data Protection Congress is to communicate different communities and associations all over the world regarding privacy and information security also matters. And now we have partners from Russia, Belarus, Armenia, Moldova, Tajikistan, Kyrgyzstan, Romania, Bulgaria, Kazakhstan, and Georgia. And of course, we have some partners from USA. All these partners are organize this Congress, and we really thank you for your participation. And without our sponsors, there will be no activities, and we're happy that you helped us, dear Comply, IDX, DRC, and HighPost. And today we also will have some session at 4 o'clock and 15:30 DPO discussion session. And let's get started. And I want to share the word with my colleague, Oleg Blinov. Oleg, let's start. And thank you very much, Wojciech Wiewiórowski, for your attendance. And let's get started.
Yes, thank you, Kristina. So I have the privilege of introducing Wojciech. Wojciech works at EDPS. Wojciech, you have the floor. Thank you.
Thank you very much. Thank you very much. Thank you for the invitation to your Congress. Thank you for the possibility to share with you some thoughts at the beginning of this English language session. Unfortunately, I didn't have the opportunity to take part in the session yesterday, which, as I know, was organized in Russian, but it's at the same time when the International Conference of Data Protection Commissioners is taking place, sorry. And theoretically, I'm in Mexico. Of course, I say welcome from Brussels, from very rainy and very windy Brussels today, sitting at home, because even the International Conference of Data Protection Commissioners have been moved online, as there is no possibility to travel to Mexico. There's no possibility to organize it in the real life. So I share the time between the zones. Today we'll be operating both in the Moscow time zone and the Mexico time zone, so that's gonna be the long day. I'm happy to meet again with the people dealing with data protection in the eastern part of Europe and the central part of Asia. We had several contacts, several conferences that were organized for the authorities, but also for the members of the lawyer societies or the data protection officers of this region. Already in the previous years, I first took part in them as the Polish Data Protection Commissioner and later on as the representative of the European Data Protection Supervisor. I will try to share with you the presentation that may probably let us go through the different kinds of cooperation between the data protection authorities, but also between the DPAs, data protection authorities, and DPOs, the data protection officers of the companies and the organizations. So that's gonna be the main topic of my today's speech. Does it work? Okay, but first of all, of course, I have to say who is the European Data Protection Supervisor. For some of you, that might be a little bit misleading to see the person who looks like, from the name of the authority, as the main data protection supervisor for the whole European Union, while it is a little bit more complicated. Because the European Data Protection Supervisor is the supervisor of the EU institutions, bodies, and agencies. So it means that I'm on equal position with the national data protection authorities. There are 27 data protection authorities in 27 states of the European Union. In some of them, the situation is even more complicated because there are local data protection authorities. But generally, there are 27 jurisdictions of the data protection in the EU that are harmonized, but at the same time, the data protection authorities are independent one from another. And the 28th jurisdiction is for the EU institutions, bodies, and agencies. But what is probably more important for us today is that the European Data Protection Supervisor is at the same time the main advisor in the process of creating the European law. So whenever the European law is either drafted by the European Commission or later on goes through the legislative process in the Parliament and in the Council, that's the European Data Protection Supervisor who is advising the institutions. While with the national law, that's the duty of the National Data Protection Authority, including the countries that are present here at the Congress, like in Romania or in Bulgaria. And when it comes to the European law, that's the European Data Protection Supervisor with the help of the European Data Protection Board that is dealing with the subject. I will say a few words about the European Data Protection Board in a while. So the supervisor of the institutions, because the institutions have to apply the same rules and the same principles as the one which are applied for the public administration in the member states, but also for the market. One of the main rules, main principles of the European law as far as data protection is concerned is that there is no significant difference between applying data protection in the public and in the private sector. Of course, there might be differences, but they are rather the exceptions from the general rule that the situation is the same. You are, I think, aware of the fact that one of these exceptions is, for example, the public authorities have less rights or less possibilities as far as the legal ground for processing of the data is concerned, because there is nothing like the legitimate interest of the public authority. The public authority operates on law, and there's nothing which can be called the legitimate interest, which can be the basis for the activity, while at the same time, this is the full legitimate base for the data processing for the market bodies, for the business, for the individuals, for the charities, NGOs, and etc., etc. But in the public sphere, it does not exist. The other difference that may appear is the difference in the finding process. So whenever the enforcement actions goes, you have to check if the national law of the member state allows to apply the financial sanctions also to public authorities, but generally the jurisdictions and the member states decided to have a similar system as the one for the business. So the European Data Protection Supervisor, as the institution which also helps to create the law, starting from the regulations, directives, so the so-called secondary law of the European Union, to the different kind of implementing acts and even internal solutions that are used in the institutions which deal with the personal data, but generally with the data. Once again, one of the things which are quite obvious, not only for the European law, but for any kind of the data protection rules which exist in the world, including the Convention 108 of the Council of Europe, is the fact that it's hard to distinguish precisely when the data is personal, when it is not. Meaning it sometimes depends on the context. So the context may mean if for this very entity, the personal data which is processed is personal or not. Also because of the other data which is in possession of the same entity. So the entity A having the resource X may treat it as fully anonymized for it, for this entity A, while entity B having some additional resource that can be matched with the resource X will actually find it personal. So it then means that the European Union institutions, when they prepare the legal acts or when they prepare the projects that are implementing the data protection, implementing the processing of the data, well, they try to go broad and to give us the possibility to have a say on everything which is connected with the data. Because of Article 16 of the Treaty of the Treaty of Functioning of the European Union, which says that everybody has a right to the protection of the personal data concerning them, but that this is the secondary law, which says how in practice it is done in the European Union countries. And the data protection authorities at the same time are dealing with the matters which are not exactly neither the enforcement of the law nor the creation of the law. So we can say, as it was said in the famous article by Colin Bennett and Charles Rabb, that we are, as DPAs, auditors and enforcers, negotiators and consultants, educators, policy advisors, but also a kind of international ambassador of the personal data protection. And this is the role which is played by each of us. And in most of the jurisdictions, even outside of the European Union, these roles are assigned to the central authorities which are dealing with the personal data protection. Well, Colin Bennett and Charles Rabb are not Europeans. They were looking at it from the perspective of the other systems which have also similar institutions. But what is extremely important and what the European authorities are very keen on is that they have to differentiate the situation where they are dealing with the personal data and the situation where they have the additional tasks, because these additional tasks may interfere in their position of the independent data protection authorities. For these reasons, while it happens that the freedom of information is at the same time the object of the actions of the commissioners who are dealing with data protection, because they are at the same time responsible for freedom of speech and for the data protection, or for the access to public documents and data protection. We try not to take additional tasks which may interfere in this sphere. And even if we do the freedom of information part of the story, we do not accept to be any kind of censors of the things which are going on, either in the classic media or in internet media. So the different roles of the data protection authorities, which we try to do being impartial, being integral, transparent in our activities, but also pragmatic. Pragmatic in the meaning that we take the world as it looks like and as it is. So remembering that the world will develop in the bad or good sense, no matter how strong will be our protest against that, and how strong we would like to drive the world to some direction. It will be developing anyway. We have to observe this development. We have to observe what are the pros and cons of the technological advancement, because while we are all the fans of the new technologies, we also have to look with the foresight look what will happen in the future, what are the trends, how to smartly approach these trends, how to build the tools with these new solutions that will help us in the everyday activity, and how to be coherent at the same time, how to remember that justice and sustainability are the pillars of our activity. Just the day before yesterday, during the International Conference of Data Protection Commissioners, which is right now called the Global Privacy Assembly, we have received as EDPS the award for the tech dispatch publications that we prepare for the data protection world, but for anybody actually in the world, on the tech developments. We also try to go further with the so-called tech sonor, trying to find what in few years, in the horizon of few years, will be the most important problem for the data protection world. But I was expected to speak today more about the cooperation, not only about building the law or enforcing the law. Well, this cooperation between the authorities is the part of the larger efforts of the European Data Protection Supervisor to be involved in the world of discussion on data protection and in the world of decisions of the development for the future. We do it with the politicians, but we do it also with all the other stakeholders, and we try to take into consideration the current situation, the situation which is illustrated also a little bit by the picture of the elevator in my own office in Brussels. That's how I found the elevator after the lockdown, with these foots on the floor, showing that the people are more and more often standing back to each other, and we start to isolate ourselves from each other, while the cooperation is the world that has to be taken into consideration and has to be the leading for all of us. In the world where there are more and more data protection laws in the world. Here you have the map from 2016, which formally shows where there was the comprehensive data protection regulation in the world. 2016. 2021, it looks like that. Formally, we have the data protection law in more than 140 jurisdictions in the world. Just 5 years, and some of the white holes have been filled. But of course, it's hard to say that those countries that are on our map shown in white are those that don't care about data protection, while those that are in blue are the ones where the situation is great. We have on this map China, which has a data protection law at the moment. It just passed the data protection law. But I'm not afraid to say that this is not the law which makes the country really observing data protection, observing the personal rights. The mere fact that the law exists doesn't, and it is comprehensive because it covers the whole market and the public authorities, does not mean that the situation is great. When the law company tries to assess the same things from their perspective, so the perspective, how important for the client, for the customer in the country, is the data protection law that exists in this country, the map may look like that. This is not my assessment. This is just the example of the assessment of one of the companies, which says that they observe European Union as the heavy system of data protection law. They observe the USA as a heavy system of data protection law, as well as China. While, for example, Russia is here treated as the moderated system. I'm saying all of that in order to show you that there is nothing like one way of assessment that can be done towards the country and towards its legal system and the practice in this country. And there is nothing like the formal assessment that can be done according to the law which exists in this country. This is actually the practice which shows how it works on the day-by-day basis. And EU, of course, European Union, of course, is usually taken as one harmonized region. Of course, without UK at the moment, but having the United Kingdom as a very similar legal system to the European one, because it's just starting from the same point. Even if they make the changes, these changes will definitely root from the same regulation as the one that exists in the European Union. Norway, Iceland, and Liechtenstein being the countries of exactly the same law, Switzerland of the law which is very similar. But in fact, the differences still exist. And for example, the age of minors the age of consent of the minors may differ in the countries of the European Union. So then the extremely important part of the story is the cooperation between the data protection authorities on the national level and on the European level and on international level. On international level, we do it in the Global Privacy Assembly. On European level, it's done first of all by the European Data Protection Board. And that's the part of the presentation which I will do in the final of our, as a conclusion of our today's presentation. The file which I leave you with the information is much larger. And of course, it's in order to supplement the topics which were presented. So the European Data Protection Board, as the main way of cooperation of the data protection authorities in the European Union, is the body which is consisting of all the data protection commissioners of the European Union countries. All the 27 jurisdictions, plus EDPS as the 28, but also plus these 3 countries of the same system as the European one, which is Iceland, Norway, and Liechtenstein, because they do have general data protection regulation as the part of their legal system, even if they were not taking part in preparation of that. All of them are meeting in the in the scope of the European Data Protection Board, which my office, EDPS, is providing the secretariat for. In the presentation, you have the long list of tasks which are for the European Data Protection Board. And I really encourage you to look at that, because in the very precise form, it has been written what kind of cooperation the bodies of the data protection authorities as the bodies can take. But all of these actions are done with one purpose, and the purpose is to have the same interpretation of the law, which is authentic in 22 languages, and which is implemented in the 27 jurisdictions, even if we think only about the national, and not forgetting that, for example, in Germany, 16 lands that exist as the parts of Germany have the possibility to regulate a lot of social questions themselves. So all answers on European law in Tallinn have to be the same as in Lisbon. The ones in Athens have to be the same as they are in Paris. So the European Data Protection Board is in this sense the most important body to cooperate. And the most difficult and the most complex system of this cooperation is connected with so-called one-stop shop system of enforcement of the law in the multiple jurisdictions. So whenever we have the cross-border case, this cross-border case have to be solved under the one-stop shop system. And that means that part of this complicated diagram, or the whole diagram as such, has to be taken into consideration. Because the general rule is that the case is to be led by the authority of the controller of the data, while it has to be transparent and decisive for all the concerned authorities where the complainants are from. I invite you to the discussion on this way of operation multinationally and comparison of that with the Convention 108 as the background for cooperation, and comparison of that with any other fora that may be useful for the international cooperation, and to get to know more about the practical problems which appear from this kind of cooperation. Knowing about the time constraints, I'd like to leave at least a few minutes for at least a few questions, but I'm ready to answer the questions also out of this question and answer time.
Thank you so much, Wojciech, for the presentation. It's been really, really great and helpful. Thank you so much. I think we have time to respond to one of the questions asked in the chat, and I will follow up with the other questions and forward them to the YouTube chat. But the first one, if you could respond in 2 minutes, could you please highlight the key challenges that EDPS is now facing in the field of data privacy? Thank you.
Well, first of all, I can say that we have to divide these challenges in several fields. There are definitely technological challenges which we see ahead of us. There are the organizational and legal ones. So let me just list some of them. If we think about the legal ones, the biggest challenge at the moment is to find out how far we can go with the legislation in order not to create unnecessary solutions or to duplicate the solutions which already exist. And also how to make one framework out of the solutions which are proposed in the acts as different from each other in the European Union as the Artificial Intelligence Act, Digital Markets Act, Digital Services Act, Data Act, Data Governance Act, and etc., and comparison with GDPR. If you think about the technological solutions, definitely artificial intelligence is at the moment the most important part of the story. However, you understand this marketing notion.
and probably surveillance, especially in connection with COVID.
Yes, that's what I would add, especially to the organizational things, because this is not rather the technology which is important here, because that's it's nothing new. What is new is that we organized the extraordinary system for the extraordinary time, according to the legal exceptions which existed in the law. But we have to answer ourselves, what out of all these solutions that were implemented for the COVID times is normal, and what is extraordinary? Because if something is extraordinary, it shall disappear when the epidemic is over.
Right. Thank you so much, Wojciech. It's been a pleasure. Thank you for taking the time.
Thank you very much, and have a good conference.
Thank you.
Thank you very much, Wojciech. And we are waiting for you on another our activities. And let's introduce another speaker, Oleg.
Yes. So next up, we have Daniela from PECB, who is a PECB certified data protection officer and a vice president of Privacy and Data Protection Specialist Association, Romania. Daniela, welcome.
Thank you, and thank you for inviting us. I would add to the previous presentation that the public institution, they have all the obligation to appoint a DPO, but private controllers should check the Article 37 to see if they need to appoint the DPO. Today, I will speak to you about the GDPR fines in Europe. And why did I choose the fines? Because the first thing, if I remember correctly, that I've heard about the GDPR was that the GDPR has the biggest, the highest fines in Europe, and everybody was very, very scared about these fines. Now we have more than 3 years of applying the GDPR, and I don't think we should have been so frightened about these fines. But what I have done in this period is learning from the fines, learning how National Supervisor Authority conducts an investigation, and what they are searching for in these investigations. So first of all, not all the NSA's websites are user-friendly, and not all the fines are published on their websites. And many times our sources are blogs or newspaper articles. The fines are published late. And the statistics compiled are based on the date of publication and not on the date of application of the fine. There are situations in which the NSA did not publish the name of the entity or the amount of the fine, and or the field in which the entity, the fined entity operates. Some GDPR fines are contested, and there are situations where they have been overturned by the courts. Sometimes links of older fines are no longer active. Some NSAs publish cases without names, amount, domain of the entity. So we identified only 2 NSAs who published on their websites how to calculate the fine applied in Germany and in Netherlands. The next statistic analysis was compiled exclusively on data from the GDPR enforcement tracker. So I will speak today about the evolution of the number of the GDPR fines and their value for the first 3 years of applying the GDPR. The top GDPR fines applied on NSA in the first 3 years. Also the fines depending on the legal basis and on the field of activity. As you can see, in the first 3 years of applying the GDPR, we had 689 fines. In 2018, there were 29 fines, but we know nothing about the amount of the four fines. Then we had in 2019 163 fines, and in 2020 351, and in 2021 in the first 5 months 146. I would add that between May and October there were another 138 fines. So I believe we will surpass the number from 220. As you can see, in 2020, it was an almost double number of fines that were applied compared to 2019. And also the total amount of fines was almost double compared to 2019. Here are some values of the fines. In Portugal in 2018, it was the highest value of one fine of 400,000 euros, followed by Spain with 7 fines. And you will see that Spain also maintained this high number of fines during these 3.5 years. Here are the GDPR fines applied in 2019. So you can see Spain applied 31 fines, followed by Romania with 21 fines. On the value of the fines, as you can see, France applied the highest fines, followed by Italy and Bulgaria. Romania is on 9th place. In 2020, the GDPR fines were, as you can see, maintaining the same top 3. As number of fines were Spain, Italy, and Romania. And on the value of the fines, Italy applied the highest values. In the first 5 months of 2021, Spain maintained the first place as number of fines and also as value of fines. On the reason for fining, we find insufficient legal basis for processing, insufficient technical and organizational measures to ensure information security, non-compliance with the general data processing principles, insufficient fulfillment of data subject rights or information obligations, insufficient cooperation with the supervisor authority, insufficient fulfillment of data breach notification obligation, lack of appointing of a DPO, or insufficient consent for the processing. As fields of activity, we find commerce and industry on the first place, media, telecommunication, radio, public sector and education, finance, insurance and consultancy, health, labor relations, physical persons or NGOs, transport and energy, tourism and hotels, real estate. So basically, nobody was out of the danger of being investigated and receiving a fine. By the amount of the fines, we still find media and telecommunications and radio on the first place, followed by labor relations. About the labor relations, if we Remember, there was a fine of 150,000 euros in Greece for PricewaterhouseCoopers that used the consent as the legal basis of processing the data of their employees. In Romania, as you can see, we also respect the same domains of applying the same fields of applying the fines as all the European Union. And also on the first place, we find commerce and industry as the highest number of fines. I did also a statistic about the last 5 months from May to October, what happened in each state of the European Union. So we find Romania with 6 fines and the total amount of fines of 10,000 euros. One of the fines of 200 euros was for a physical person. I will add that in Romania we have a big difference between the public sector and the private sector, because the fines of the private sector are from the GDPR, so we have 4% of the affair cipher, and also 20 million euros. But for the public sector, we have about 4,000 euros, so something very similar. In Austria, were 4 fines. As you can see, the amount is very, very high, over 60 million euros. Cyprus 3 fines, Denmark 8, Finland 2, France 4, Germany 1 fine of 900,000 euros. Greece with 6 fines, Hungary 1, Iceland 1, Ireland 2 fines, of which only one of them was for over 225 million euros and was applied to WhatsApp for insufficient fulfillment of obligation of information obligations. Italy had 12 fines, and the amount was almost 7 million euros. And the highest fines were for non-compliance with general data processing principles. Latvia 1 fine, Lithuania 1, Luxembourg 7 fines, and 746 million euros was the fine for Amazon Europe for non-compliance with general data processing principles. Norway 8 fines, Poland 3, Spain, as you can see, remains on top with the 60 fines, with more than 3 million euros. Sweden 7 fines, United Kingdom 1 fine. So in these 5 months were applied 138 fines, and the total amount is 989 million euros. If we compare to the amount from the first 3 years of applying with the GDPR, we find it that it's almost 5 times more than what was applied in these 3 years. And the total number of fines in 2021, all 9 months, was 284 fines.
Daniela, while we're on the topic of like recent developments, I'm sure you noticed as well that in the new SCCs, the data importer has to notify the exporter and the supervisor authority regarding breaches. Does this mean that there will be an uptick in fines in an extraterritorial manner, given that GDPR is effective outside of Europe? There may be a situation where the regulators will want to fine companies that are not incorporated in Europe. Do you see potential in the next couple of months or year for that?
I can tell you what I'm seeing in Romania. So these transfers of data are still continuing. We don't have any fine for this kind of transfers. We all know the activity of NIOB from Austria. Till now, nothing happened, but I'm expecting the next year that something will start happening. I can see that the number of fines per total domain remains very, very high. And probably the controllers, as you can see, is all this period of pandemic, they are concentrating on other things than the GDPR, and probably they leave at last regulating this transfers also. So yes, probably there will be some fines in the next year.
Okay, Daniela, many thanks. Oh, sorry, I just want to add, Petros, you can start sharing your presentation because yes, we have a little short time slot. And Daniela, thank you. I want to remind that Daniela represents our partner from Romania and its Privacy Association. Thank you very much for your contribution to the Congress. Oleg, I give you word.
Yes, we have next up Petros, a data protection officer at Wargaming, with a presentation on privacy challenges in the gaming industry. Petros, very nice to see you. Go ahead.
Happy to be here, Oleg. Thank you. So, hello everyone. My name is Petros Eleftheriou, and I'm the data protection officer of Wargaming. Wargaming is an online game developer and publisher operating across PC, console, and mobile platforms. As a DPO, I'm leading the organization's global privacy program, working on different EU and non-EU privacy projects. Apologies. Moving to the agenda for today, agenda-wise, I will discuss the privacy developments and challenges gaming companies are currently facing, both from an increasing regulatory landscape perspective to the regulation of minors, and also we'll discuss the challenges posed by the privacy and data protection regimes, as well as other relevant laws which form part of each country's digital agenda. So today, I will begin with from the regulatory landscape and what does this mean for the gaming companies. Gaming companies operate on multiple jurisdictions, meaning that online video games and mobile game applications are made available or distributed via digital platforms across the world, therefore attracting a number of users from different jurisdictions. In light of this, gaming companies are required to comply with different privacy and data protection regimes and are often taking the role of the data controller as a direct relationship and interaction that we have with the users. Despite that, data protection regulations we are in place for many years, such as the European Data Protection Directive, the predecessor of the GDPR, those were not designed for the digital environment. Then GDPR was the first groundbreaking attempt to protect the personal data from technological developments. The GDPR imposes a number of obligations to the data controllers, from the principles to lawful basis, to data subject rights, and also to other obligations. Since the application of the GDPR, other jurisdictions have also started implementing or taking measures to reform their data protection laws. For example, in California, which we saw that last year has adopted the California Consumer Privacy Act, entered into effect on 1st of January 2020. The CCPA creates obligations for businesses and provides certain rights for consumers similar to those under the GDPR. One notable consumer right, however, which cannot be found in other jurisdictions, is the right to opt out of the sale of their personal information, which requires organizations to post a link on their website that says, "Do not sell my personal information," and then to allow consumers to opt out of the sale of their personal information to third parties. There is a specific definition of the term sale. What does it mean under the CCPA? Sale means it's broadly defined under the CCPA and means any transferring, disclosing, or making available personal information. So the word sale must not be interpreted in the literal meaning, selling the information, but also entails transferring and disclosing of personal information to third parties. Of course, take into account the certain peculiarities of the requirements of the right to opt out of the sale of personal information. To highlight, the CCPA will soon be replaced by the California Privacy Rights Act, which was voted by the Californians last year, which introduces additional obligations to businesses, such as the right to rectification, the right to limit use and disclosure of sensitive personal information, and also the obligation to maintain a record of processing activities. We saw recently in China that they have announced the adoption of the Personal Information Protection Law, which will take effect on 1st of November 2021, in a week's time. Despite the similarities with the GDPR, especially in the philosophy of the law, there are some key differences that organizations should consider. China, as we know, it's a very big market, especially for the gaming industry. And there are some specific requirements on how to treat and handle the personal information of Chinese users. For example, under the new Chinese data protection law, financial status, location tracking, and personal information of minors under the age of 14 are considered and classified as sensitive personal information, and controllers must obtain independent consent from the individuals. In regards to minors, however, those that are under the age of 14 must obtain additionally the consent of the minor's parents or guardians. The law also provides several mechanisms for transferring personal information abroad. For example, conducting security assessment organized by the Cyber Administration of China, apologies, which is the Internet watchdog of China, and also or to enter into standard contractual clauses similar to those found under the GDPR. Of course, the Chinese authorities are yet to release such templates, and as they promised, they will soon, in due course, clarify certain aspects of the Chinese Personal Information Protection Act. Finally, the Chinese law establishes data localization requirements. Entities that are handling personal information within certain thresholds are required to store information that is collected and generated within China domestically. So this is a data localization rule, which there are similarities, I would say, with the one found under the Russian federal law on data protection. Data protection in Russia also is governed by several laws, including the law of personal data, which entered into force back in 2006, and follows a similar approach to the European data protection regime, to the old European data protection regime. Other notable laws include the law on information, the so-called also data localization law. Moreover, multiple bills are currently going through the legislative process that may bring changes generally to the Russian data protection regime, such as the bill on digital financial assets and the bill on the digital profile. The global trend of jurisdictions introducing or seeking to introduce more robust data protection laws will most likely continue. We have also different US states' privacy laws that are currently going through the legislative process. We have also some other US state laws that have already implemented similar data privacy laws with the one of the CCPA, like Colorado, Virginia, Nevada. Also, we have Canada, which has introduced the Bill C11 for the Digital Charter Implementation Act 2020, aiming to reform its current data protection regime. Very recently, Ukraine has registered to Parliament a draft on personal data protection law. India is discussing a new data protection law. Australia also is set to reform its Privacy Act of 1988, and other European developments on the regulations of cookies and tracking technologies, and very recently, the announcement of the UK government to reform their UK GDPR. So I guess the key question here is, how do you comply with all these regulations? How do you comply with all these privacy and data protection regimes? This is a tough question. There is no answer, definitely, especially for the gaming companies operating globally. Many are wondering whether you should set the bar high and adopt a single data protection law as a gold standard. For example, they are mentioning GDPR as being the strictest one. Therefore, adopting it and implementing its requirements should comply with all the rest of the regulations. Despite that, a lot of people support this view. Nonetheless, there is no one-size-fits-all solution. Definitely, each regulation has its own philosophy and requirements, and it all comes down to the specific requirements of the organization. For example, to the operations, activities, structure, and size of the organizations to understand what is required to be done and implemented. A good starting point, I would rather say, is to map your data to get an understanding how the data flows from and to your organizations, record your technologies. It's very important, as the assets are the places where data sits and stored. Also, as the approach of the GDPR and the philosophy of the GDPR is a risk-based approach, and similar approach we see from other companies, from other laws. It's very, very important to identify the risks related to your activities and mitigate those. Also, it's very important to know your processors, third-party risk assessments, vendor lifecycle management, which means that when you onboard or offboarding a vendor or a processor, it's very important to track and monitor how they process and handle the personal information trusted to them. Also, of course, as a matter of good data hygiene and good data practices and data governance and framework will definitely help companies to comply with all these regulations.
Petros, I have a question that is quite practical in that given that GDPR has an extraterritorial effect for companies incorporated in Europe, how do you go about the problem of combining several legal basis for processing, where, for example, under local law, it has to be compliance with the law, and under GDPR, it has to be, for example, legitimate interest. How do you combine the two, given, for example, for legitimate interest, you have to implement the right to object, and at the same time, you have to comply with the local law? So what would be the approach in terms of like transparency and the mechanics of it?
Mm-hmm. So if we take, for example, the CCPA, the California Consumer Privacy Act, there is no, the philosophy, first of all, in US is different. The philosophy of protecting the privacy of US citizens comes to the fact that everything is permissive unless it is prohibited, meaning that there is no legal basis for processing personal data. To the contrary, the European privacy perspective takes the other way around, meaning that everything is prohibited unless it is permitted specifically. In US, there is no legal basis, no principles to comply with. So somehow you are entitled to process the personal data of the US citizens unless they request to stop processing their personal data. This is not the case, of course, in the European Union. And also, this is not the case also under the new Chinese law, which also they impose lawful basis and principles to comply with.
All right.
Okay,
Thank you.
Petros, thank you very much for your presentation and your participation, and for us cases and practical knowledge of Wargaming, and your special, as you're really excellent experts in this field, are really important for us as a community and for us as experts. So thank you very much.
Do I have about 2-3 minutes, more minutes, perhaps? No?
Unfortunately not, but
okay.
we invite you to our coffee break, which will be at 14:30. I will also send you a message. You can join to this coffee break session. And what time left for your topic, we will start from your side. So if you want, just join and text me. We will wait you at 14:30. And now I want to give the word to Oleg. Thank you very much.
Thank you very much,
again.
Petros.
And now I want also introduce my colleague Irina Shermina. Irina is active expert from Russian Privacy Professional Association. And also, she head of Direction Privacy and IP Tech Law of CMS Russia. And Irina will moderate today's sessions, a part of each. Oleg Blinov is also is. And I will give you a word, Irina, and let's introduce Oleg. Thank you.
Thank you very much, Christina. I'm happy to join, and I'm also happy to introduce Oleg as the next speaker. Oleg is a global DPO from Joom, and also he's a member of the board of the Russian Privacy Professionals Association. And today Oleg will talk about privacy through tech, a showcase of homomorphic encryption, a very intriguing name of the presentation. So Oleg, the floor is yours.
Yes, thank you so much, Irina, for the introduction. I did present the same topic yesterday on the Russian side, and I'm happy to share it today on the English session. And the main idea behind the presentation is a dichotomy that exists in the current tech. It's basically that the technological development of today's society, on the one hand, always creates risks for data subjects. And we're always experiencing this, for example, in terms of public surveillance and how the governments need less and less data to identify us in the crowd. At the same time, we should be looking at technology as one of the ways to resolve the privacy problems that we are facing as data subjects. And when we think about ways to protect us, to protect our privacy, of course, technological protection measures are probably the first one that come to mind. And the first among them is encryption. And we'll talk about how basic classic encryption works. So imagine you're a diplomat in the Middle Ages and you want to send a message to your king. So you have some sort of information that you find valuable and secret. While you write it down in an understandable language, that's called clear text. And you have this message in the leftmost part of the screen, which has a green background. And green means here that it's safe. So while it's in your hands, it's relatively safe, and say you can have it in clear text. And your monarch, he or she also wants to read this message, and we trust this reader. So we want to have a clear text at the other side. But we do not trust the intermediary, the person who will deliver the message. And therefore, we use encryption to cipher this sort of message into an unreadable form, which can then be turned back into a clear text message. And while the message is being transported, it cannot be interacted with by the intermediary. And the history of encryption goes back to quite a lot of centuries, and it isn't a new development really. And it's been really helpful. The problem with the current world and the technological challenge that we are all facing is that protection of communications channels does not make it. For example, let's take the scenario of hosting. Let's say we have a web application where multiple users access this sort of application and provide their data, for example, address data, names, emails, whatever you name it. So the user inputs this sort of data into his or her user device and sends it to your web server, which is hosted, for example, by Amazon. It sends it through a secure communications channel, which is encrypted by HTTPS, and it's safe while it's there. But at the same time, at the moment that it enters the hosting provider, it has to be decrypted in order for you to exercise your business logic on it. So you have to process it, you have to change it, you have to modify it, etc. In order to do so, you have to decrypt it. The problem with hosting and basically any type of software as a service, as a cloud service, is that other actors may access this data. For example, if it's a hosting provider, maybe there are public authorities who wish to gain access to this data. For example, with American companies under the Cloud Act. The other scenario is, for example, analytics. If you want to use a cloud analytics service, for example, BigQuery, for example, Amplitude and others, you have to provide them with the data. And I'm noticing that more and more providers are naming themselves not only as processors, but for some purposes, they say they are the controller because they are developing their service and they're doing it for their own benefit. And this is the problem, that in order to receive the benefit of analytics tools, you would have to decrypt the information and then trust the service that it will not do nefarious things with these things, that they will probably use it for their own purposes. Now, this is where the homomorphic encryption comes into play. Initially, it was designed to withstand any break attempts by quantum computing. Is because quantum computing is much more efficient at breaking current encryption methods, and we have to basically develop new mathematical methods to counter that. And homomorphic encryption is very fun in that way that you still can perform computations with regard to encrypted data without decrypting it. So in order to understand how it basically functions, we have this presentation here with the screen where, for example, I have two balls. One says 6 and the other says 3. And I want to add one to another. But say I don't have the computational power to do so. I don't have the methods and the framework for performing these mathematical operations. I have a provider, a cloud provider, who is willing to do these computations, but I have to upload my data to it. So in order for me to do it safely for the data that I'm holding, if I do not want to disclose my initial numbers, 6 and 3, to the cloud provider, I would have to encrypt both of these numbers. And here we see that 6 turns into 100 and 3 turns into 200. Then I can transfer this data to the cloud provider who can perform mathematical operations with it. And he or she gets the result of 300. Now the 300 result can be transferred back to me into the green area where it's safe. So it's, for example, my computer, where I, using the decryption keys, can turn 300 back into the sum of 6 and 3, and I get 9, without disclosing the inputs and the outputs to the cloud provider. Now I have, in order to be fully presentative, I have developed a web application which plays out a situation where, for example, we are a research center that focuses on finding out how many people are currently ill with COVID. And we don't want to compromise the confidentiality of hospitals, but we want to get the end result. And for this, say we have the initial number of patients that we have on our file is currently 0. We encrypt this data and we get a combination of numbers that cannot be turned back into 0 without the decryption keys. So now we send this data to the hospital. And do you see that hospital 1 received this data? It cannot understand what the content of this of the string is without the decryption keys, and we have not provided them with the decryption keys. But they can still add their number of patients to this and receive an output. This is still an encrypted container that it can send to hospital 2. Hospital 2, when it received the encrypted container, cannot understand what our initial data was, nor what hospital 1 added. So it says, for example, I have 20 more patients. It calculates a new encrypted container, which it can then send back to the lab. So this is where we step back in. So it's our lab. We want to understand what the sum of all the participants was. And we click decrypt and the response is 30. So in receiving this sum, notice that we compromise the confidentiality of none of the participants. So hospital 1 or 2 did not know what our initial number of patients was. Hospital 2 doesn't know what the initial data was, nor what hospital 1 received. And when we receive the data back, we do not know what hospital 1 added and hospital 2 added. We only know the end result. So this is what basically a scenario for use of homomorphic encryption would be. In fact, there are already live applications of this technology. It is used by Gmail in order to power your spam filters. It's also very beneficial for machine learning because machine learning requires quite a lot of data to train the neural network. And at the same time, you will need to disclose data in order to make use of a trained model. However, if you encrypt the data and use machine learning to learn on the encrypted data, you will still get the result without compromising the confidentiality of the data. And furthermore, it is used in advanced analytics tools. For example, Google BigQuery is already offering the functionality of homomorphic encryption on the cloud. In fact, I'm thinking that in the near-term future, we'll have a boom of privacy tech developments. For example, I'm helping my friends at the startup Sovereign, and they perform personal data discovery in transit. So basically, within your system, there are several servers or subsystems that are constantly communicating with each other. For example, you have a database that contains the user accounts, and then you have the advertising email database that goes into the first database to fetch the email and then send some marketing communication. And then you have this chatter among different systems. Now, if you insert a proxy service between these, you can monitor what kind of data is being transferred. And for example, if you insert there a prohibition to use the data if there has been an upsubscribe event, then this proxy, this intermediary between the services will, for example, block any transfer between these two services where it has been prohibited by the user. So there are quite some sophisticated decisions on the market already. I would also take a bit of time to tell about my own solution that I have developed. It's called eConsent. It's a solution for consent management, which is quite actively used under Russian law. And the best I could make of it is to provide users and data subjects with the most easy way to send requests of withdrawal of consent, as well as to see what kind of data is being processed by the controller. There are also solutions by our partners at B152, a Russian consulting company, and they're building an automated compliance automation solution. Furthermore, Facebook, although I'm quite critical of Facebook, is indeed moving quite rapidly into the space and developing privacy-enhancing technologies, which you can see at privacytech.fb.com. For example, they are developing multi-party computation as a solution to privacy problems. So I'm really hopeful that privacy tech will provide a lot of solutions to privacy problems that we face today. Thank you so much for your attention. I'm happy to respond to your questions if you have any.
Thank you very much, Oleg. Maybe not another question, but a comment from my side that I'm really happy that privacy tech is developing. This is exactly what we need right now, and I wish a lot of luck to your personal activities and to your collaboration with others. So,
thank you so much.
Yeah, thank you very much.
Could you also add, Oleg, just quick question for 1 minute. You also presented your tool, consent management, which is free for some number of people. Maybe our English-speaking colleagues also will interested. Will you translate the interface to English, or these tools only will be available to Russian-speaking audience?
Well, currently we are mostly targeted at the Russian audience, and my initial thought is that if anyone is interested in the English version, Google Translate plugin in Chrome is very much accessible, and it translates most of what is said. But given that transparency is a global value, it does indeed make sense in the future to make it globally available and globally oriented, and English will indeed be a working language for that. Okay, thank you very much, Oleg. Irina?
Thank you so much. So we are moving on to our next speaker. It's Diana Buciuscan. Please correct me if I said it wrong. So Diana is a DPO at Moldcell. It's a Moldavian telecom company, and she's also a member of Privacy Research Association. And Diana will talk today about law enforcement authorities versus privacy. Diana, and I thought Christina would like to.
Yeah. Thank you very much, Diana. Could you please just start sharing your presentation while I adding some words about you? I'm really grateful for your participation on this Congress as a partner. Diana presents also our partner for Moldova, and thank you very much. It's really very important your contribution to the Congress. And so let's get started. Thank you.
Hello.
Yes, thank you. Diana, we can see it. Could you please make it full screen, the presentation?
Yeah, I will try.
Yes.
Is
great,
it okay?
thank you. Yes, yeah. Perfect.
Okay, I'm sharing the full screen, so I don't see any more you. So if something goes wrong, please just tell me. Okay, thank you, Christina. Thank you, Irina, for introduction. Hello, everyone, and thank you for having me. My name is Diana Buciuscan, and I'm a DPO at Moldcell. It's a telecom company in the Republic of Moldova. And I'm going to speak about this dilemmatic topic about the law enforcement authorities versus privacy. So
I'm sorry, Diana, before you start moving on,
yeah,
we do not hear you well. It's kind of far away, I think, for us. Could you please modify something if possible?
I don't know what to modify. Is necessary?
Try to talk near the microphone. Yeah.
And now, is it okay?
I think the sound goes to your notebook, to your computer, not to your microphone. Maybe.
Try without your headphone. Yes.
So what about now?
So it's the same. So probably we need to plug in.
So let's continue, colleagues. Yeah.
Okay.
Yeah. Let's continue.
As you say.
We can understand what you say. Yeah.
Okay. So I will start with a few facts about the history and the evolution of data privacy in Moldova. So in 2007, we have adopted the law on personal data protection that has been repealed in 2012. The authority that is responsible for control over the compliance of personal data processing in the Republic of Moldova has become a national center for personal data protection. We also, in 2008, the Convention 108 was enforced. However, we have ratified it in 1999. Also, after that,
we had very interesting government decision on requirements for the assurance of personal data security at their processing within the information systems of personal data. Also, meanwhile, in the current law on personal data protection, there are several articles regulating the processing of personal data by law enforcement agencies. In 2015, have been established the instruction on the processing of personal data in police sector. In 2016, have been implemented some elements of personal data protection in law enforcement legislation. And also, we have drafted in 2016 a law known as Big Brother. It was registered in the parliament, but contains several gaps, even if it was submitted to public consultations for a longer period of time, and the authors initially did not take into account the recommendation of national, even international experts, including those of the Venice Commission. But in the end, no actions have been taken in this regard. Also, during the period of 2017 and 2019, we had an EU twinning project to harmonize the Republic of Moldova's national legislation in the field of data protection with the European Union's legal framework. So that in 2018, we have drafted a package of personal data protection laws based on GDPR and based on the Data Protection Directive 680 that have been put in first reading by Parliament. Well, but at the moment we have a lot of debates based on this draft. Just recently I participated in several working meetings where have been engaged the national authority for data protection, even some experts from EU, like the director of the Latvian State Data Inspectorate, sharing their experience, even some business associations and other experts for producing the best possible version of the law, because we have some controversial debates in this regard. But finally, we have agreed for a version that satisfies all opinion. So we are now waiting for the second reading approval from Parliament in order to have a law based on GDPR, because the current law at the moment is based on Directive 95. By the way, the Republic of Moldova is a member with the observator status within the European Data Protection Board starting from 2018. So the acceptance of the Republic of Moldova on this status is the first and probably the major achievement in the Eastern states, because at the present the Republic of Moldova is the only state that holds the status with the European Data Protection Board. Well, in the same time, from practical point of view, the law enforcement authorities have presented some resistance during the period 2011-2016. In their view, the personal data protection law does not apply to criminal cases, but in 2016 have been established some changes to 8 laws, like law on National Anti-Corruption Center, Code of Criminal Procedure, and so on. By the way, even have been implemented, or I could say appointed a DPO within some law enforcement authorities. So it's a big change further. But as have said Giovanni Ducarelli, supervision is an essential component of the fundamental right to data protection, and the level of intensity of supervision should not be dependent on the sector where the personal data are processed. So if we move on the practical point of view, as I said earlier, I'm a DPO and a telecom company, so we are related actively with the law enforcement authority, and we have a well-established process of interaction with the law authority agencies. And I will share some of our experience in a nutshell working with them, how we are interacting with the police, how we support, let's say, human rights and freedom of expression. So as a telecom company, we are obliged by national law to respond to requests and demands from authorities to disclose some customer information. We have this obligation specified in local law and based on specific reasons such as enforcing criminal law and safeguarding national security. So in this regard, we have to make this balance of legal obligation and customer privacy. For the first, we have established this process. The main objective of these processes was a single contact point for authority requests, so that to guarantee that all requests are handled by authorized and qualified personnel according to national laws and according to our internal requirements. This is providing some clarity towards authorities, also protect customers' privacy. So we have well-defined roles, responsibilities, and ownership. Personal user accounts and stroke authentication. If there are any misusing handling processes, we are focused on personnel that has access to customer personal data. So all authorized persons handling authority requests are informed about all these procedures, internal procedures, and in case the request for information is received by, for example, an unauthorized employee, the requesting authority will be instructed to contact the correct contact point. So all the requests for information made by authorities are always processed through an authorized team. No other employees shall any circumstances made to disclose information to the authorities. Also, another objective is the request handling process. We have a unified way of working that is guarantees that legality and validity of this request that are received are verified. So all authority requests are documented and based on requirements set by law. Exceptional requests or some situations that are handled they all are handled in a similar way, but if there are some exceptions, always they are reported to the top management. We handle the request in this regard to fulfill all local legal and internal requirements in accordance with our internal policy on freedom of expression in telecommunications. And by the way, authorities do not have direct access to our system. However, some interfaces are in use for some specific sub-services. For example, local interception systems are neither owned nor controlled by telecom company due to local legislation. All information is disclosed to competent authorities only to the extent required by local law. Another objective is to establish the documentation, to have very detailed guidelines to define roles and responsibilities, to make agreements. So in order to have a guarantee or a reliable service, reliable reporting, to enhance this privacy and the freedom of expression of our customers, and of course to contribute to a reflecting of proper limits for government surveillance powers. So when we talk about documentation, we mean policies, instructions, guidelines, procedures that apply to the extent that they do not place the company in violation of domestic laws or regulations, including license requirements or another legal restrictions on disclosure. The last objective is training and communication that are essential. From a security perspective, clear communication to all employees and training of local employees working with the tasks related to authority service is very important.
I'm sorry, the time is running, so if you could just make a couple of points and we'll finish.
Diana, you also could join us at 14:30, and we can continue with your presentation.
But I think the last point would be okay right now to conclude and finish.
Okay, I have some case examples that I just thought to discuss about, but I think we could discuss on these case examples that I have in the presentation in the following discussions, or even in the DPO discussion. Why not?
Of course, yes. And just check your sound again, maybe without your additional garniture, maybe because it's really not so good sound.
Okay.
So,
thank you very much.
See you today on our future sessions, coffee break and DPO session. Yes, thank you, Irina.
Yes, thank you.
Yes,
thank you very much.
Thank you, Diana. Thank you very much. And we'll move on to the next speaker. It's Janis Razna, DPO from Riga, Latvia. Janis will talk about algorithm of personal data breach notification to the supervisor authority, as we know, a very hot topic. So Janis, we're glad to welcome you here. The floor is yours. Please share your presentation.
And also, Janis, hi, thank you. Thank you very much. Also, I want to add that the next speaker will be at 30 minutes and 1 o'clock at Moscow time. And Janis, we are happy to keep you here for 30 minutes, 15 minutes for your topic and 15 minutes for discussion. Let's get started. Thank you.
Yeah, so please, colleagues, share your questions. We will have a chance to discuss them. So Janis, please.
Okay, so hello to everyone. I'm really happy to be here. I'm really happy to share my experience. And before I share my presentation, a small introduction with me. I had a first touch with personal data like 6.5 years ago when I was working as a head of HR department. And as an HR department head, we have a lot of employees, a lot of personal data, and then somehow I started to learn more about data protection, and now already for last more than 4 years, I'm working only as a data protection officer, and I have a lot of experience related to industry of aviation. I mean, flight companies, airports, all this process, how our personal data are circulating between these companies, flight companies, airports. This is also very, very interesting. But now recently I have switched to healthcare industry, and this is very challenging because mostly of the time I have to work with Article 9 of the GDPR. And as we all know, Article 9 is about special categories data. In my particular case, this is all about personal data related to health, and this is very challenging to be compliant with the GDPR, but we are doing our best, and let's get to our today's topic. And I today wanted to share with you my experience with how to notify supervisory authority about personal data breach, because when you are reading the Article 33 of the GDPR, it is kind of easy, and it is so my presentation a little is stuck. Hold on.
You just push. Yeah, it's okay. It's okay. If you want to change your slides, just turn on the slide and use your arrows on the keyboard. Just try to share. Yeah.
Yes. It's all fine. So Article
We
33 of
do
the
not see it now, Janis. I'm sorry. We don't
Yeah,
see it.
share the screen again.
Hold on. Yes, I'm sharing the screen again. And do we see the presentation now?
Yes, we do.
Yes, the algorithm of recording and investigating personal data protection breach or notification to the supervisory authority. As we all know, Article 33 of the GDPR says how and what to do if we have a personal data breach. In the first paragraph of this article, it is said, and we all know this legendary 72 hours after we have becoming aware of personal data breach, we have to notify supervisory authority. And a lot of DPOs are discussing about this, and a lot of companies are frightened about this, how to manage to get this notification to supervisory authority in 72 hours. But there is a second part of the article, and it said in there that unless the personal data breach is unlikely to result in a risk to the rights and freedoms of natural persons. The first, when I started to work with personal data breaches, and in my experience, I have an average 5 to 7 breaches in a year, or notifications about breaches. And when I started to work on this article, I had to develop like a new internal rules for me how to work in such situations, because the article says you have to be sure that there is risk to the rights and freedoms of natural persons, or there is no risk. So my main question, always working with the personal data breach and before notification to the supervisory authorities, to understand that there is or is no a risk to rights and freedoms of natural persons. So the first step, in my experience, is that we have to start an investigation about all this situation, because if some of employees said that, hey, Janis, after your learning about personal data protection, I understand that I sent an email to another employee I didn't want to send, so this is a personal data breach. But before, we have to understand if this really is a breach. So if this email contained the personal data, and what kind of personal data, and to whom he sent, and is there or is there no risks to rights and freedoms of natural persons. So what I did when I'm working, what I'm doing when I'm working with personal data breaches, I'm splitting out, or I'm hanging out such a definition as personal data event. And this is something before personal data breach. I mean, if we have to understand if there is a high risks to the personal data, to the data subject rights and freedoms, then we have to somehow confirm this, and that's why I'm splitting out another definition called personal data event. And in my opinion, the personal data event is a possible but not confirmed breach, and this is our task to know, and in the result of an investigation, to understand if this is really a breach, or we just have a doubt about that the breach could be over there. And as we all know, personal data breach could be when personal data has been disclosed or accessed without authorization. And to confirm that yes, personal data has really been accessed without authorization, I think we have to use, or we have to have something like provement for such a situation. That's again about when personal data has been corrected or changed without authorization. If we have a data subject compliant that in my cards that the personal data have been changed without my authorization, so before I say yes, somebody changed your data, I have to investigate. maybe this data subject gave such a wrong data, and then there will be no breach. So I'm calling all this while investigation is carried out. This is personal data event. Okay, next, what is the algorithm of the process I'm using? And this process is only, in my experience, how to deal with practical issues when you have to notify supervisory authorities. So the first moment an employee or another source of information can give us information or a notification about personal data event. Immediately after this, data protection officer or somebody else of the company who is performing data protection officer's duties is recording this information in the personal data event register. And this is done immediately, and this is also the first step of principle of transparency that we can afterwards easily show to supervisory authority what we did and how we did with the information we received. So when the information about personal data event is registered in the register, the DPO starts the event investigation. And in this stage, a lot of information should be gathered. DPO can talk to head of IT department, head of budget department, head of HR, to anybody he thinks it's unnecessary to talk. DPO is talking, and he's talking to employees involved. He's taking explanations from them. Also, he's gathering all kind of information to understand what's happened and why we have this notification about personal data event. So if a data breach is not connected, and also we have to be sure that in such situation, no risks to data subjects' rights and freedoms are detected, then the investigation report is submitted to the board of the company. And this is also the next step of transparency principle, that we have a notification, we have registered it, then we have an investigation, there will be a lot of documents gathered, and then there is a report of investigation, and this report is submitted to the board. And also in this report, there will be written that in DPO's opinion, based on gathered information, the data breach is not detected, and also the risks to rights and freedoms of the data subject is not detected. Afterward, what is happening? DPO prepares an answer to the submitter, and within 30 days, DPO also prepares a recommendation report to the board of the company. And in my opinion, in this recommendation report, there should be or could be a lot of information. For example, a recommendation to carry out another data protection impact assessment, or there can be information for personal data audit, or there can be a suggestion for changes to the process how personal data are processed, or there can be whatever we need information just to be sure what was happened, and the recommendation to not have such situations in the future. What next? If DPO, in the result of investigation, understands that yes, data breach is detected, and also the risks to the rights and freedoms of the data subjects are detected, then again, DPO submits his writing down the investigation report, and DPO submits this report to the board. So again, transparency principle. The company knows what is happening with personal data in company and what is going on. So afterwards, the investigation report is submitted to the board. The board confirms the breach. This is kind of small, but in my opinion, very needed action, because in my experience, I have been talking to a lot of DPOs, and the level of awareness of GDPR is different. So in one case, one DPO thinks that everything is a personal data breach and we have to notify supervisory authority about everything. But there are such DPOs who can say, no, there is no any risks to rights and freedoms of the data subject, so we do not have to notify. And in my opinion, the board over here in this step is like a third part in all of this situation, and the board can confirm, or if they are not confirming the breach, they have to explain why they are not confirming. But anyway, they will make this decision based on the investigation report, which is submitted to the board by the DPO. And when we are moving on afterwards, when the board confirmed the breach, then from this moment, there are these 72 hours in which we have to notify the supervisory authority. And this in this particular case, I think 72 hours is plenty of time to get ready to prepare letters, to prepare all information which is needed to be submitted to supervisory authority. And when we have sent notification to supervisory authority, then again DPO prepares an answer to the submitter, and also DPO within 30 days prepares a recommendation report to the board. And the final step in all this algorithm is active action of the company to prevent such or similar events in the future. So in my opinion, when we are reading the Article 33 of GDPR, it is said only 72 hours and you have to notify. But actually, when we are working on these issues in real life, then this is not that easy, because the process is, as you see, much longer, and it's much complicated than written only in the article. So, as I said, the key point is we have to investigate, and while we are investigating this personal data event, no breach, we have to split out before that this is personal data event. And afterwards, when in the result of investigation, we see yes, the data breach is detected and there is risks to rights and freedoms of that subject, then we are just switching the red button and we are preparing a notification information to a supervisory authority. So this is my algorithm of how to notify supervisory authority and how to deal when you have information or notification about possible data protection breach. So, colleagues, now I will be happy to answer your questions if there are some of them.
Yes, Janis, many thanks. Also, especially that you wrote me some question regarding GDPR, and this question ended at your participation in the Congress. So thank you for your mailing, and we are really happy that you participate in this Congress and sharing your knowledge with us. I know that Irina has some questions to you, and it will suppose our discussion for 10 minutes, I hope. So, Irina.
Yes, thank you, Christina. Thank you, Janis. Very interesting. You mentioned at the beginning, and it triggered both Christina and I. We were discussing this in Telegram now, that you worked in aviation with airports and flight companies, and
yes,
we all know how much data is processed there. So, did you face any situations where you had to report data breach, or if not, what kind of specifics can you disclose to us with regard to this particular field?
Actually, the question, I understand the question is very interesting, and probably we can discuss this all data protection breaches somehow separately, because flight companies and airports is critical infrastructure, and we cannot easily share information about this. But mainly, I can tell that flight companies and airports were the one of first companies which started to deal with GDPR, and there are a lot of money involved in this to get ready and to be compliant with GDPR. And actually, this circle, how we are giving our personal data to flight companies, how they are giving them back to airports, and airports are giving back to flight companies, it is kind of simple, and it is very secure. I can share with you information that it is safe to share our personal data with flight companies, and it will be also safe when flight companies share our data to airports in any direction we are flying to. So I would like to say that industry of aviation is very safe according to our personal data, wherever we are flying to, because there are a lot of international standards they have to be compliant with, and also with GDPR. So maybe this is also the question why I changed recently my position to healthcare industry, because there is a lot of healthcare and personal data related to special categories, and yes, a lot of work over here.
Yeah, and less regulation. I mean, the regulation is there, of course, but it's not that probably detailed as with the airport. Interesting, thank you, because we recently discussed the case about Bologna Airport, where they had a problem with privacy by design, and there was a case about their application where employees could share some suspicious activities, etc., and that was the fine. So we were kind of surprised that it could happen with the airport, because it's kind of a big entity, But it's interesting interesting to hear your experience. Thank you very much. And we have also a couple of questions in the chat. I think we can bring them together.
Okay.
So first is, does the board in the presentation mean the board of directors? And second, from the same person, Karina, should 72 hours be counted after the board confirms the breach, not 72 hours after occurrence of the event?
So yes, I mean, in the presentation by board is the directors of the company. And so again, about these 72 hours, please repeat the question.
So from which moment should 72 hours be counted? From the confirmation from the board of the breach, or from exactly. The occurrence of the event?
No, exactly. The 72 hours I'm counting from the moment when board confirmed the breach, because as I said previously, while there is going on investigation about this, I'm saying that this is only a personal data event, and event is not a confirmed breach, because like I said this example, if some employee comes to me and says, "Hey, Janis, I sent an email to another person I didn't want to," and I cannot at the same moment say that yes, this is a personal data breach, and if I will send such a notification to supervisory authority, it will sound funny for them and funny for me. So I have to confirm that yes, that in that email was personal data, and what amount of personal data, and what was the purposes of these personal data. And only afterward, when I figured out that yes, if there were special categories data, if there were a lot of like employees' home addresses or phone numbers or something else which is disclosed to another person, then yes, this is personal data breach. But I have to, in the result of investigation, confirm that, And about this board of directors, this is very important principle that company itself have to know what is going on with data protection in its premises. So this information to board is very, very important. And if DPO is responsible in a board and is directly working under the board, it is, in my opinion, just logical that I have prepared an investigation report. I'm going to them. I'm saying, yes, we have a major issue, and I'm telling all this situation. And afterwards, they are saying, yes, Janis, you are right. Thank you for this report. We confirm that breach has happened, and you are welcome to notify supervisory authority. So this is how it works in real life, because as I said, in the last 3 years, I'm working with data protection events like in average 5 to 7 times a year. And when you are going through this process, there are some things you can like manage or evolve to be very sure about what you are doing.
Mm-hmm. And what about the situations when, for example, board of directors does not agree with DPO and says, oh, no, nothing special. We do not want to report. We do not want, to bring attention from the Data Protection Authority to our cool company. Did you have such a situation, or if not, how would you react in principle?
Mm-hmm. Very good question. No, in my experience, I didn't have such a situation, but it could be such a situation because DPOs work differently, and if DPO is submitting to the board, to the director of the board, like a very poorly made investigation report, then there can be situations that board rejects to confirm the breach and said, but hey DPO, you have to ask to head of IT what happened. You cannot just make such a big decision only by your I don't know, about your poor investigation. So there can be such situations, but they must be like very explained why board is not confirming such breach. But in my opinion, in my experience, no, I don't have such situation, because when I'm working on these issues, I'm working really like in a surgery. Everything is cleared out, everything is asked, everything is written down, and afterwards, if board rejects, then anyway, I have a lot of investigation materials how I can prove that I made everything 100% from my side. So there can be such situations, but then the first question will be to the DPO. Why board rejected your investigation report?
Yeah, but it also means that the board should be really, thoughtful and involved in the process. So they should really deeply understand what's going on, and probably they need to be really well aware of the data protection legislation. So that means that you need to train not only your employees as a DPO, but also the board itself. Maybe first thing you need to train the board, because they really need to understand the consequences.
I can answer easily to this question, how I'm dealing with that. Actually, every 2 weeks, I'm participating in the board meetings, in the highest level board meetings. And every 2 weeks, I'm talking to them about data protection issues. I'm sharing with them world experience, all interesting finds and situations, and what company are found in every country, and what was done or what was didn't. So this is my experience, how I'm involving the board. These can be like 10 to 15 or half an hour, but every 2 weeks I'm participating in the directors of board meeting in the highest level, and they are listening to me, and I am explaining all these issues. So if we are not dealing with GDPR, then we will probably have a fine, and not only a fine. This is how they listen to me, and they are aware of GDPR. And this is my suggestion for all of DPOs. If they are local, I know that there will be a discussion later today about it is better to be a local DPO or outsourcing DPO. And this is one of advantages. If DPO is local, then he can participate in such meetings and explain, like in daily situations, why we have to deal with GDPR.
Yeah, indeed. Thank you. Very interesting experience. And by the way, are you outsourced DPO or your in-house DPO?
I'm an in-house DPO, but there are few companies I'm outsourcing also. So I have both experience. But mainly I'm in-house and for few companies also outsourcing. So thank you for discussion.
Thank you very much. Thank you very much. It was very interesting.
We can't stop. We can't stop because there were a lot of questions. And if you want to just join to us at 14:30 at coffee break, and we also will discuss with our other participants some basic issues and important issues of privacy. And Irina, let's introduce.
Yes, thank you, Janis. We are moving on. Thank you. We're moving on to Paul Stoica, if I'm correct. He's a Vice President of Privacy and Data Protection Specialists Association from Romania. And he will talk today about the role of DPO in creating a data privacy culture. A very important question that I think we a little bit triggered right now with Janis, and I think it's a good start for your presentation.
And also, Paul is our partner. And thank you very much for your contribution and also attendance of our Congress. So let's start.
Yeah, Paul, the floor is yours. Thank you.
Hello, greetings from Romania. Very interesting subjects today, and I hope there are more to come in the next hours. So let me share my screen. Just a second. Can you see?
Yes, perfect. Thank you.
Okay. So I have a big subject today. 15 minutes is not enough, but let's start with this. The role of DPO in creating a data privacy culture. So first, some things about me. I have a strong background of IT. I'm more a practical man, not someone into law. I have 4 years experience as an external DPO and a consultant for several private and public organizations in Romania. I'm also a privacy by design and privacy by default software architect because I work with several companies that design software. I'm also consultant for ICO 271 and 2732 cybersecurity and 31,000 risk management. I'm also a pen tester and cybersecurity consultant and enthusiast. Also, I am working with privacy and data protection specialist associations in Romania, which is a group of specialists, mostly DPOs, where we can help each other and share some of our questions in this domain, and also have big projects like a survey of GDPR implementation in public organizations in Romania. And also this group likes to think that we can reunite all the voices of DPO in one strong voice in Romania, and maybe we can have a single point of view about some aspects of GDPR. So being practical, I always ask myself which are the tasks of DPOs. The tasks are presented in Article 39 in GDPR. And I will pass on them because I think this one aspect, awareness raising, is one of the things that we are interested in today. So we work in privacy, but the GDPR asks us to raise awareness of this term. I don't know, the privacy is a fundamental thing for people. Don't we understand what privacy means? I mean, we have to protect data, but do the subjects of the data processing know what is privacy and personal data? I will focus in the situation in Romania because I know this country well. So traditionally, we all know what personal data is, and we all respect privacy, but mostly only when this concerns us. Others' privacy is not so important to us. And maybe you you recognize this kind of picture because in some small communities or some companies, everybody likes to know everything about the others. Everyone tries to talk about the others' businesses, and they all respect privacy, but privacy seems to stop at some point, and everybody understands this. For example, in one company, every employee knows what the other employees are doing and doing in private time, like where do they spend their vacation, what kind of things they bought, and what kind of health do they have. Then they meet at some free time, and all they talk about the other colleagues. In a small community, like a small village, I don't know, at the local shop, everybody knows everything about the village people. They know how much they spend, what kind of things they are interested in buying. So it is privacy, but not so privacy. But let's go for the other example. We have, let's say, documents found in on the street because somebody lost it. What should we do? Of course, in Romania, we post them on Facebook or maybe in a shop's window because we need to help the people that lost their documents. And the single thing we can expect to do is to share this information. We don't care about their privacy or their private documents. We only want to help them, right? And this kind of things we can find in other examples, like we have Facebook groups where we can share pictures with people that have parked their cars in wrong places, and everybody writes something about this. And in small villages, of course, the people that are represented in the pictures, the cars are recognized. Everybody knows that it is that person who has made a wrong park. Going forward, let's talk about the institutions, because maybe people, normal people, do not know what privacy is or where to stop. But surely institutions are doing the best what they can do. So let's take another example. Recently, I was asked by an institution to go with some documents to them, a copy of my IDs, and make an annual, I don't know what to say in English, to give them my annual information about me. So they have a procedure in this pandemic time where I had to put my documents inside a box at the gate of the institution, and in the closing hours of the institution, the security officer of that institution had to collect all the papers and take it to the department that have asked for these documents. So this kind of picture illustrates what kind of box I had to use. This is privacy by design and by default at an institution in Romania. But of course, my documents are going to a specialized department where only authorized people will access them, right? This is a normal view in Romania, where a desk of an employee of an institution has hundreds of papers about which contain personal data, and there isn't enough space to store them. So let's take it forward. After the data is not longer needed, the institution, of course, will destroy the data, taking all the appropriate measures like this. Another not so friendly image, but it happens. So what did I wanted to say is, we all know what personal data is. We all respect this and the privacy of the others. So we are a DPO, and it is a simple job to do for us, right? Another subject, who is talking about privacy, because it is clear that the people we address do not understand what privacy is, or do not understand what personal data is. Generally, in Romania, the press is talking about GDPR and privacy, but in reality, they are talking mostly about fines. You know, they say Google has a fine of 50 million euros, or some bank did something wrong and they got another big fine. The people will always think that GDPR applies only to the big players, not to the whole spectrum of companies or institutions in our country. So there is another way of talking about privacy, as I'm part of some groups of specialists, and we always discuss implementations or specific cases, or let's say contractual agreements about GDPR, but in reality nobody reads them. Or we make privacy policies, but in a website the user will not read them, only get over it, and of course they will give consent to everything that comes on the screen. And the feeling is, we work in a domain, but nobody really cares about it. What can we do in this case? This is, I come to the subject of my presentation. Remember that we as DPO, we are in the first line of contact with the real people, both the employees, both the employees. And I think we have this opportunity to make awareness from the bottom and talk about privacy in their own language. So I would suggest not to make this awareness rising from the perspective of the controller, from the perspective only of the regulator, but from the point of view of normal people. Because you know, the controller or the company sets the processing of some data, but they are normal people too, and they have different level of knowledge in privacy or law terms. And if they do not understand what they are doing, they will require some incorrect actions. So we need to talk to them in clear and simple language.
Well, I'm sorry, you have a couple of minutes left.
Yes, I will finish immediately. So what we are needing to do, we have to start from the bottom, from the lowest employees to the top management, and explain that data surround us, and mostly every action in a company will require the data processing. Make a lot of examples and explain them why data privacy is important for them and also for the company. Make them understand that customer perception is changing. The customer will require special attention to their data. So if an employee makes a wrong decision, that decision will affect the company also and the image of the company in the market. Maybe we can make them understand that data, personal data, is economic asset for companies, and at this moment you have to get the leadership on the board and make them understand that they have to align all the actions of the company by putting privacy in the core of the business. Of course, this requires a long time, but remember, every small contribution of us as DPOs count as raising the awareness of privacy.
Thank you very much, Paul. It's a very interesting topic and very important one, as we also know from Janis' presentation. So I hope those pictures were not real, pictures from the processing of data. If they were, I really hope that this will not be the case anymore in the nearest future. I think we need to move to the next speaker. Thank you, Paul, again very much.
Thanks.
Thank you very much, Paul, and have a nice time. And if you want, just join to us at 14:30 to our coffee break session.
Sure.
And see you soon. Thank you, Irina.
Thank you very much. Yes, we're moving to the next speaker. It's Adrian Ciobanu. I hope I correctly pronounced it. And he's owner of Reimens Group, and he's also privacy consultant and DPO as a service provider. So Adrian will talk about DPO methodology to access and take over new clients, which is a very interesting topic, Adrian.
And also, Adrian is represents our partner from Romania. And please unmute yourself. Yes, thank you.
Chris, thank you very much for this kind introductions. Thank you for having me here. And I hope I will complete my agenda of my colleagues with something specific from our day-to-day working. I will try to open my PowerPoint and to share my screen with everything I have here. Just a second. Okay. Now, this is full screen, Chris.
Yes.
Confirm it's everything all right? Yes. Everybody hear me? The light is on, and you can see me also very well. So I decided for today to present you something very specific from my day-to-day activity working with my clients, and I hope this will be helpful for some of you who are new in this business. About me, about the speaker, I want to tell you just few words important for this moment of the presentation. I have 20 years in consultancy, 3 years at DPO as a service. So I'm young in this job. I delivered technical assistance for GDPR compliance for over 20 accounts in the last 3 years. I'm a DPO as a service for 7 clients right now. And in between, I delivered trainings for privacy consultancy, DPO mentoring for some other opportunities, depending on the situations. I am a certified CIPP E and member of IAPP. For those who don't know who is IAPP, is a United States Association for Privacy Professionals. I'm passionate about cybersecurity, and every day I spend at least 30-40 minutes to explore what is happening in this cybercrime industry and to keep up to date my clients regarding this unfortunate situation regarding the cybercrime. I'm a member and ambassador of the association, a specialist in data protections. And also, I would like to add something to what my colleagues said already. We monthly offer education for our members. It's very important because our member of the boards, our older specialists, prepare every month some materials to educate all the members of the association. So it's not just a place where we feel good to each other, where we share some problems and try to find solutions. It's also a place for education for everyone involved in this organization. So let's start about the DPO. First of all, I want to tell you that it's a personal perspective. It's not something that some institution put it in the guide or something. It's just my experience as a DPO in the last 3 years, and please don't judge me too hard. I use 3 kinds of contracts, usually. Only a DPO as a service, so those who don't have one, but they believe they are compliant. DPO as a service and technical assistance for compliance. So I deliver something more than DPO as a service. I help them to implement all the details and all it's necessary to be compliant with GDPR, and technical assistance for privacy compliance only for those who have a DPO, who don't know what to solve some problems and so on. This is kind of contracts I use in a day-to-day activity. First of all, I want to share with you a privilege I have. I accept only clients that have management fully committed to support me in a process I want to deliver, or a DPO or technical assistance. This is very important because I had an unfortunate situation where the management team was not so committed regarding the GDPR. They were not so interested about the implication of not being compliant. So I decided to work only with the clients where the CEO sponsor me and sustain me for all the steps, because I don't know if you are aware, but the DPO is not a lovable guy in the company. He is the boogeyman. Yes, he's the one who tried to change the life of all the other guys from sales, marketing, and so on. So nobody loves the DPO except the CEO. Important, along with the contract, I signed a DPO working methodology containing, in the first place, all the parts should know the obligations we have. Yes, I want to tell them what I believe is my duty during the contract, what is my perspective regarding their obligation, and how they can and should support me, and some disclaimers, of course, because some things are agreed in the first stage of the contract, and then the same things are forgotten in the next 6 to 1 year period of time. First of all, when we start the contract, it's very important, in my opinion, to have an engaged meeting with all the management staff, where I share with everyone involved in this project the roadmap we shall follow together, about the responsibilities they have, and my expectations regarding the collaboration I need to have with them. In other words, it's about the modus vivendi. Yes, don't forget to establish the condition before you start the contract. Otherwise, you'll have many problems. First step after the meeting is a assessment of the account. Where you are, Mr. Client? What is the distance you need to fulfill to reach the GDPR requirements? Yes. Also, I need an InfoSec assessment made by me with some simple tools provided by some institutions specialized in InfoSec. So after the meeting, I evaluate the level of conformity of my clients, because after that, for me, it's important to establish the next step as soon as possible. The training and awareness I provide with my training programs developed by me, and 3 of them, the most important, and I do not negotiate this, is GDPR fundamentals for all the people who process all personal data. Then InfoSec training for cybersecurity awareness in the online environment. It's very important to rise the level of the security of the company by education, because as we all know, the education is the most efficient way to protect the company against the cybercrime. There is no other way. You can have any kind of hardware, software, or other services. One unattentive employee can bring you the ransomware inside of organization. In addition, every week, every month or week, I provide newsletters regarding the cyber threats, regarding some details from the GDPR. I remind them the principles, the lawfulness, the rights of the data subject, just to keep them warm, the memory. Then I provide, and we start the process register assessment. And I want to know if they have a register with all the processes, how it's done, and how can we improve this. Yes, it's very important. After this, another assessment, we start to identify the vulnerabilities and threats upon the organization. This is based on the evaluation I made in the previous stage, but also here I involve deeply the IT guys and the IT companies who knows better the details regarding the information IT environment and problems. Then we have the risk assessment. The risk assessment, it's also very important. You can start building this risk register after you have enough information, but it's very important to educate also the company and the people involved in the risk assessment before we start the assessment. What is the risk? How we perform the risk assessment? What is the methodology and the tools we need? Yes. Also, I build a team who help me to construct the risk register. Yes, it's very important to follow these steps, because before appearance of the DPO, nobody knows what is the privacy risk. Nobody knows how is done this assessment. Yes, and why we do it. So I encourage you to provide a workshop with all the parts interested in this stage. It's time now to start building an action plan. Yes, it's very important to put on the paper all the next steps you should follow to reach the GDPR requirements. one of my decision in the last year is to start every kind of stage with a workshop. Regarding the processing register, the company should have in fully and very accurate. I also provide a workshop if they don't have it one built by our meeting. I provide a workshop where I explain every cell in the file, what is meaning, why we collect that data, and what is the requirements of the GDPR. So this register is critical for me to be done in a very accurate way. I also provide a workshop for transparency and consent, because I believe there are so few companies who have an inventory of the notices or consents, and they have a consent management to handle these documents in a proper way. Also, I provide a workshop regarding the processor and joint controllerships, because they should know that they have to protect themselves, but also to use the addendum GDPR controllership documents and so on. Incident management plan training, it's very important. I provide this training during the technical assistance program, somewhere after the risk assessment, because after that moment, I know what is the level of the exposure of the company to the threats and cybercrime. So I construct an incident response team, I train them, and then we together develop an incident management plan based on this training I provide before.
Adrian, thank you so much. I think we run out of the time.
Only 13 minutes. I have
I
have the clock in my phone.
Yeah. So, but thank you very much. I think this is a very useful presentation with the action plan, actually. And I think, as Christina mentioned, you are more than welcome, and we'll be very glad if you join us at 2:30 for the coffee break and share more information.
Okay, thank you very much for your presentation. It was really useful, and if you can share each with our attendees, I think that they really...
Anyway, you can contact me on my email, and we can discuss after that anytime.
Okay.
Thank you for the time, guys.
Many thanks. Damyan, you can start and share your presentation. Yes, Irina.
Yes, next speaker is Damyan Todorov from Bulgaria. He's a privacy and data protection professional and also a member of IPP and Privacy Council at Association of Data Protection Officers. And he will talk about Bulgarian data protection reality from a DPO perspective. Damyan, very welcome to this Congress. Happy to have you here. If you could share the screen with the full screen of your presentation, that would be amazing.
Hello, yeah, I'm sharing it now. It's okay?
Yes,
it's not a full screen, but yeah,
you can choose. Okay.
Nice.
Damyan, thank you very much. And I also want to add that Damyan represents the Association of Privacy Data Protection Officers of Bulgaria, and this association is our partner. And thank you very much for your contribution in the Congress. And let's begin. Thank you.
Thank you.
Yeah, thank you. Hello, I'm very honored and excited to participate in this great event, and I hope that my presentation will be interesting for the audience and to provide, of course, valuable information about the Bulgarian data protection reality. First of all, let me introduce myself briefly. My name is Damyan Todorov, and I'm a privacy and data protection professional located in Bulgaria. At the moment, I'm working for the Association of Data Protection Officers in Bulgaria and present a part of the data protection officer as a service team. If you want to know more about me or about our association, you can find us at my personal blog or contact us at the website of our association. We are very open and we'll be happy to have contact with other professionals from around the world. So I hope that we can network together even online. But I hope that we can meet in person sometime when the times are better. So without further ado, let's jump to the topic of my presentation, the Bulgarian data protection reality. Just to give you brief information about Bulgaria, the country became a member state of the European Union in the 2007. For this reason, obviously, it's mandatory to apply the GDPR. What is more, in terms of the national legislation in the field of data protection, there is a special legal act called Personal Data Protection Act. And this act actually expands the effect of GDPR in certain areas and also imposes additional obligations for controllers and sometimes for data subjects. Also, another very important specific of this act is that regulates the establishment of the data protection, National Data Protection Authority called Commission for Personal Data Protection. In this context, from our experience as DPO working with organizations from both public and private sector, I'd like to share with you some of our observations about the controllers from both public and private sector. Let's see. Let's first talk about the controllers in the public sector. The majority of public organizations appoint for DPOs employees that have another main position in the organization. And for this reason, it is common for them to lack expert knowledge regarding data protection and conflict of interests usually arise. What is more, another, let's say, disturbing observation of our association is that many of these DPOs are not interested in participation in trainings and other initiatives for gaining more knowledge, which is sad, according to us, of course. Several landmark cases of personal data breaches in organizations like the National Tax Revenue Agency show that usually security measures are seriously neglected and the results are devastating for a great amount of data subjects, unfortunately. Next, there are enormous amount of examples of careless processing of personal data by institutional websites and administrative online services. Of course, much can be said about these organizations, but I think it's very useful to compare what is happening in the private sector. So let's focus on the private sector organizations. We have to say that although there are some similarities between public and private organizations, in the private sector, controllers have obviously another perspective on GDPR. In the vast majority of cases, their understanding of GDPR is as another administrative burden that is imposed by the bureaucrats from Brussels. On the other hand, it is true that some companies do demonstrate involvement into GDPR compliance, and they are willing to improve their current level of GDPR compliance. It is common companies to go for appointing DPO only if it is mandatory, but they do that usually as a last resort to bypass their obligation under GDPR. When it comes to international transfers and data processing agreements, many controllers tend to neglect their obligations that are set by the GDPR. And also it is common, some of them just to be not aware of their obligations. So it's not a surprise that they neglect them or they don't apply. Well, all mentioned to this moment is of course related to the role and the activity of the National Data Protection Authority, called Commission for Personal Data Protection. In our perspective, the Commission is not often proactive and rarely exercise its powers to full extent. From our experience, the Commission is resistant to cooperation with NGOs and other data protection professionals, which is sad. Another striking characteristic is that the Commission is not providing enough guidance and barely promotes awareness towards the controllers and the data subjects, and the result of that are not very satisfying. Well, as DPOs, we experience the challenges every day, and in Bulgaria, there are a lot of, let's say, factors that have importance for the everyday activity of DPO. As we are providing data protection officer service as a service, we have an outside perspective to our partners and clients, and we have more objective point of view when it comes to overseeing the organizations we work and how they process personal data compared to their internal business processes. But in overall, we can point four main challenges for DPOs in Bulgaria from our perspective. DPOs have to be proactive and persuasive, very persuasive actually, towards the controllers regarding GDPR compliance. Also, a must is the high level of understanding and knowledge of legal and technological aspects of data protection. So DPOs have to have profound knowledge of law and technology at the same time if they want to be on high level. That's what we believe, and that's what our experience is about. In terms of law, when speaking about the legal part, keeping track of the practice of national courts regarding data protection is crucial because, as I told, we have the National Personal Data Protection Act that in fact imposes additional obligations to controllers and sometimes set extra restrictions for processing personal data. Last but not the least, I should say, the scarcity of credible and useful data protection literature and resources in Bulgarian is also very problematic for many DPOs. That's because many of them, especially the ones that are appointed at public organizations, are not very proficient in English, and that's why for them it's really hard and problematic to educate themselves and improve their knowledge only with the current literature in Bulgaria. Of course, there are many more that can be added to this list, but this is a topic for another presentation, I believe. So to wrap up, thank you very much for your attention and having me. I hope you all stay safe and meet each other in the next edition of this amazing event. Thank you.
Thank you very much. Thank you, Damyan. Indeed, we hope that next time this Congress will be live and in person. I see that our next speaker is already here, so unless Chris would like to say something.
Yes, thank you very much, Irina. We're just trying to cooperate with two moderators, and I think we didn't fail with this goal. So, Damyan, thank you very much again, and your presentation was very interesting and useful. We hope that our future cooperation between our associations will be done and in life, of course. And Selin, hi. Just before Irina will introduce you officially, I'm really glad that you come to us. And I remember that we first met at the EPP conference and have a lot of good conversations and attend a lot of different speakers with different topics. So I really can't imagine that in future you will participate in our Congress, and I'm really happy that such our actions and privacy issues uniting people all over the world. So Irina, let's introduce our speaker.
Selin, good afternoon. I'm happy to welcome you here. And we probably also met at IPP event, but yeah, now we definitely will remember that we met. Selin is a managing partner at Ozbek Attorney Partnership. She's a chairperson of the Data Protection Association, sorry, that's the next step, Association in Turkey. And she's also a dual qualified lawyer in Turkey and solicitor in England and Wales. And Selin today will talk about requirements for registration, appointment of a representative for foreign controllers in Turkey. Quite an important topic. So Selin, I see that you are trying to
yes. Can you see? Yes. Can you see the presentation?
Yes, we can see also the something on the bottom, but I think it's okay. We can see the presentation.
Sorry, I think yes. Thanks again. Sorry, I think the presentation. Let me see. Yes, there's. Let me try to share it properly.
Sure, no problem.
So yes, thank you for the invitation again. And my name is Selin Ozbek. As you mentioned, I am the managing partner at Ozbek Attorney Partnership, and I have the privilege also to be the chairperson for the Data Protection Association in Turkey, where I have many Turkish privacy practitioners and academics and lawyers. Have the privilege of working with them. The association has been active since 2017 and became formally formed as an association in 2018. We are very active and organize trainings, workshops with different industries and sectors, work closely with the authority, and also issue white papers on interesting topics in Turkey. Today, I will be speaking about the obligation to register with Turkish Data Controllers Registry. And I will very briefly touch upon the Turkish legislative environment and then explain the registration requirements, what needs to be done, and what can be the consequences of non-registration. The Turkish legislative environment is actually new compared to European peers. The data protection law in Turkey was enacted back in April 2016. And following the law, the Data Protection Authority in Turkey was established. And the law imposed certain obligations to the Data Protection Authority, one of which was the establishment and safekeeping of a data controllers registry in Turkey. Data Protection Authority, following that requirement, worked on an online registry system called Verbis, and it is introduced to Turkey in 2018. This registry is a publicly accessible registry via the Data Protection Authority's website. and anyone can access the information there. And it is for data controllers, both Turkish data controllers and foreign data controllers, as well as the public authorities. There have been certain deadlines since the establishment of the registry, and although the registry was established back in 2018, the transition period will end as of 31st of December 2021 for all data controllers. The first deadline was actually different for certain data controllers, but with the COVID in place, the deadline was extended several times. So the final deadline is 31st of December for all types of data controllers. Here on the presentation, you see that there are different categories. One is the general obligation for companies, and then there are requirements for specific categories of data, and then requirements for foreign data controllers. So for data controllers, the Data Protection Authority in Turkey issued certain exemptions, and those exemptions were issued in different time periods by different board decisions, and they involve certain categories of data controllers like notaries, associations, lawyers, accountants, or mediators. These are actually controllers that are exempt from the registration requirement. But general threshold is for companies with less than 50 employees, or with a balance sheet less than 25 million Turkish liras. Those are, if they are not processing sensitive data, they are exempt from the requirement. It is important to note that those exemptions actually apply for Turkish companies, not foreign companies. So for foreign data controllers, no exemptions are applicable. If they process data related to Turkish individuals, they will be required to register with Turkish Data Controllers Registry. So you will be asking, where does it come from? Does there any extraterritorial scope defined under the Turkish data protection law? My answer is no. There is no article like in GDPR, Article 3 of GDPR, about defining the extraterritorial scope of Turkish data protection law. This requirement for registration for the foreign data controllers comes from the secondary legislation, a bylaw for the establishment and keeping of the data controllers registry. And it is applicable for all types of data processing activities. So different than GDPR, you will not be looking for monitoring or provision of services or goods to Turkey, but it is very wide in nature and not very well defined in the law. But the requirement comes, as I mentioned, from the secondary legislation. The requirement to register with the controller registry started back in 2018. So that was a start date when, after following the establishment of the registry, the online registry called Verbis. And it is a process, and this is an ongoing process. So many controllers have already been registered with the registry. And if you visit the website of the Data Protection Authority, you will be able to see a detailed explanation of their processing activities and transfers and detention periods and the security measures they are taking. But there are many others who were not registered with the registry, especially the governmental authorities, which their deadline started very late. And for all types of controllers, the deadline will finish in 2 months in December 2021. So what is next? As it's called the name suggests, it's a controller's registry. So you need to determine whether you're a controller or a processor. If you're a processor, obviously you're not required to register with the Turkish Data Controllers Registry, but it is not always easy to determine if you're a controller or a processor. So for a foreign controller who owns a company or establishment in Turkey, can be a branch or a subsidiary company, it will be maybe important to determine whether the activities related, processing activities relating to Turkish individuals are within the control of the Turkish entity or the foreign company. If it's the Turkish entity who processes the data relating to Turkish individuals, then the registration requirement will be obviously applicable for the Turkish company. Otherwise, the foreign parent company may need to be required to register with the Turkish Data Controllers Registry. For companies that have branches in Turkey, there was a decision from the board which made it clear that the branches were maybe, in most of the cases, in principle, be required to register with the controllers registry. And for liaison offices, however, this was made clear that the requirement lies with the foreign entity, not the liaison office. So when it comes to registration with the controllers registry, there are a few actions that need to be taken. So the first step is to, as I mentioned, determine whether you're a controller or a processor. And if you're a controller, you need to determine the identity and the address information of the controller, and also appoint a representative and a contract person. The representative appointment is a requirement for foreign controllers. That is similar to GDPR maybe. And for the data controller, there needs to be taking certain decisions and empowerment for appointment of the data controller's representative in Turkey. That controller's representative must be a legal person or a legal entity in Turkey, or a Turkish citizen, if it's a real person, and it needs to be, or he or she needs to be empowered with certain powers to represent the foreign controller vis-a-vis the Data Protection Authority and the Turkish individuals. And the contact person is different, and it is applicable for Turkish companies or Turkish controllers and foreign controllers. It is a real person that actually is appointed to manage the relationship with the Data Protection Authority. That is a little different when it comes to powers and duties. As you can see, the representative has a power to represent, and the contact person is basically the name in the registry for the authority and the individuals to contact and communicate with. So what is needed to register with this system? As I mentioned, it is an online registration system called Verbis, and the controllers need to go through the registration process. Once they have a representative and a contact person, certain data needs to be filled in and uploaded to the system. So identification information for the data controller, what type of data is being processed, data subject groups and data categories need to be mentioned. The process of the purpose of data processing needs to be determined for different categories and different groups. And recipients and recipient groups need to be also determined and uploaded to the system. For a data controller to go through this process, there's a requirement to prepare a data processing inventory. This is similar to the practices in Europe. You need to really go through all your processing activities and what types of legal grounds you're based your activities, and what type of data security measures you're taking, especially when it comes to technical and administrative measures. What are the measures being taken by the controller? These all need to be registered with the authority. Not very much in detail. It's a catalog basically provided by the system. It's a straightforward process, more or less, but it needs to be in compliance with the inventory you are keeping as a controller. That is a requirement for data controllers to keep an inventory for their processing activities, and that is the basis for the registration activity as well. It must be in compliance with the inventory. Whenever you publicly available, must be also in compliance with the inventory. So,
sorry, just 2 minutes.
So this is a requirement, as I mentioned. It's a not new requirement. It's been there since October 2018. So what is the consequence of not doing this? Obviously, there are administrative fines applicable under the law, and it's different than GDPR. They are not percentage based. There are monetary limits. And for not registration, the upper limits of the fine is approximately $215,000 US. These are updated every year by the legislation. And however, I know it may not sound very high as an administrative fine, but there's also one other consequence for non-compliance, which is a possibility for cease of processing by the authority or transfer of data outside of Turkey. I think this is an important consequence for non-compliance compared to the administrative fine, and needs to be taken very seriously by the foreign controllers.
Selin, thank you very much. I think it's very up to date for us as well in Russia, because we have a similar requirement in Russian legislation, but the consequences are not that harsh, thank God. But still, very interesting to hear that you have similar experience. Thank you very much.
My pleasure.
Okay. Thank you very much, Selin. And I just noticed that you also participated in the association, and some real very top role in your association in Turkey. And I want to offer you our future cooperation between your association and our community of different associations. So over the world.
Thank you. That will be a pleasure. Thank you so much.
Thank you very much. And if we will have a time, we can add you to this Congress and add information about your association, and we will present you on our third day tomorrow. So let's keep in touch, and I will text you information. Thank you very much.
Thank you very much. Thank you.
Irina.
Thank you, Selin. Thank you very much. So we are moving on to the next speaker. I hope he is here already, and we'll see him in a second. Yes, perfect. It's Darryl Anthony, the privacy lead and DPO at Miro, which I personally adore as a service. So Darryl will talk about vendor risk management. So Darryl, the floor is yours, and we look forward to your presentation. We see it, which is great. We do not hear you yet, but we see your presentation. We hear Selin instead. Darryl, we saw your presentation. It was great on the screen, but now it's not. It's not there. We still cannot hear you because you're on mute.
Fantastic. Can you hear me now?
Yes, perfect.
Oh,
but
brilliant.
we don't see your presentation yet.
And that's because it is hiding. 2 seconds, folks. Technical issues. And voila. Yes, hopefully you should be able to see the screen now.
Yes, we do. Thank you. Fantastic, Darryl.
Fantastic. That's very kind of you, Irina. And sorry about the technical issues there, folks. Clearly, I'm having an issue with the IT side of things. But I wanted to thank you all for having me here today. It's an absolute pleasure to be here and part of the Congress. I must say, I'm quite excited to talk to you about vendor risk management and privacy. And in particular, I wanted to just thank everybody for arranging this fantastic Congress. It's really a pleasure to be here. A little background about myself. So as explained, I am a solicitor based a solicitor based out of the UK, and I am a privacy lead for Miro. In a previous life, I worked for a few FTSE 100 companies, and I've been fortunate to have been involved in a number of sort of privacy programs. One of the key areas in any privacy program is your vendor risk management, or VRM. And today I want to talk to you about vendor risk management and privacy. So without further ado, right, so what is vendor risk management? So vendor risk management basically is the process of identifying and mitigating risks with your entire supplier estate. What we find in the modern business world is that procurement is very fast-paced, and organizations require us to onboard and outsource to organizations that are better equipped to provide the services. So there's definitely the business driver there in relation to outsourcing. So it is very much a necessary component to modern business. And within any vendor risk management program, there's going to be a variety of compliance considerations. Some of you may be aware of things such as, anti-bribery or FCPA or sanctions checking. But today what we want to talk about is basically data privacy and data protection within your vendor risk management program. I suppose the key takeaway for anybody that's watching this today is that if you don't have a reasonable VRM in place or vendor risk management program in place, this can also be a vulnerability. So whilst there are advantages to outsourcing and vendor onboarding and making your business sort of agile and streamlined and growing to enable the business, it can also become a serious privacy and security consideration if this is not checked. So what I wanted to do is also sort of take a minute to sort of explain the various privacy drivers that will involve data privacy being embedded within your vendor risk management program. Things such as data asset protection are very important. In particular, how do you manage your information lifecycle management, records retention, things such as brand building, managing your risk, protecting your brand, very important. Extended enterprise, relationships with partners, service providers, assigning responsibility and accountability for how you manage these relationships. In particular, we find with joint marketing and so forth, where you potentially have two controllers and lots of individual rights queries. Another area that's ripe for growth is advances in tech. And any sort of technology lawyers or data privacy lawyers or security personnel that are on the call today will know that things such as the Internet of Things, social networks, technical solutions, biometrics, AI, all of these things keep us up at night, right? But at the same time, they're very integral to the way we operate as businesses in a fast-moving world. And therefore, integrating privacy into these things is vital. Another element to consider is globalization. So lots of global companies need to be able to offshore services, implement global programs around things like, customer relationship management tools or your HR systems. And these are continuous areas of improvement from a privacy perspective as organizations scale. Things such as, outsourcing benefits, payroll, this is where employee data management is very much a privacy driver in relation to vendor risk management. And what we also find is, increased regulation. So we all fully aware of the GDPR by now, I hope, but basically we've got to be able to demonstrate accountability. There are multiple jurisdictions around the world that have similar regulations, and being able to build in a vendor risk management program that can help you navigate various data control requirements around the world, I think would be key to businesses that want to scale. And of course, the last point I want to talk about is customer sensitivity. Those organizations that have customer bases and consumer bases, there's an increased sensitivity to aggressive marketing practices and analytics. Some of my colleagues were talking about, the DPOs are often shunned when it comes to talking to marketing teams and so forth. And this is why I feel like, having a very good vendor risk management program at the very start of the vendor engagement will help alleviate some of those future issues that we encounter in operationalizing these things. So what I also wanted to highlight, folks, was that, vendor risk management is truly cross-collaboration. Us as privacy individuals or privacy individuals or data protection individuals simply can't do this on our own. It's going to require a lot of effort on the part of the privacy individuals to break down those barriers with the folks in procurement, sourcing, legal, and security to ensure that we have a one-size-fits-all approach to the organization's vendor risk management. It is a highway. Organizations are fast moving. They expect onboarding to be pretty much done within weeks. And of course, that provides us with a number of challenges. And you can see the toll booth there. And I suppose the message I'm trying to convey is that we don't want to slow the traffic down. We want to help the traffic to sort of flow in the right way and maintain the highway. And that's where I see us as the sort of toll booth as opposed to a sort of blocker. And that's an important consideration within your vendor risk management risk appetite framework. Right, so I also wanted to talk to you about what would a privacy review process look like? Basically the what. It's a key part of the privacy program. It's also part of your accountability framework. It's a process by which we are able to assess those data privacy risks, right? And in particular, what do we want to achieve in that assessment? Well, on the column on the left, you see personal data, sensitive personal data, proprietary information, and so forth. This is the sort of data that we want to protect. And we do this in a collaboration with our security partners. But we take a much more closer view on things to do with compliance with data privacy laws on the right-hand side. And what I've done there is just map some of the articles from the GDPR to certain controls that you can look to embed and build within your vendor risk management program to make it seamless. Things like being able to verify that you've provided the correct levels of transparency and notice, evidencing your compliance as a data controller, or ensuring that transfers of personal data are compliant with the international transfer laws, which we all know is quite a hot topic at the moment. Now, to do all of that, you need to have a very reasonable vendor risk management program and have to consider how you're building these controls within your privacy assurance review, which is part of the overarching vendor risk management program. So there's a number of considerations when you are managing a program. And I wanted to talk to you about the 4 key ones as I see them. So the first one is understanding the roles of the parties. Within the privacy landscape, that could involve, is it a controller? Is it a controller to processor to processor? And there's a few more different solutions in there. But I think to enable the privacy folks and the business to understand the role of the parties, you have to know your data flows and you have to know what the services entail, which means you've got to do a wee bit of due diligence or privacy assurance. Another key point to remember is that within the contractual provisions and within privacy, we have standard provisions for each type of activity. Normally, it's a data processing addendum, or standard contractual clauses, or combination of the two. But within vendor risk management, always bear in mind the vendors' contracts will want to limit risk, and the controller's attempt at the contract will want to sort of increase their ability to flow down exposure and limit risk. So contractual provisions form a key part of your vendor risk management overarching program. But also a key point to bear in mind, right? There's no point in letting in the vendor, checking everything, and then forgetting about them. And this is, I find, one of the more risk-based approaches that organizations can take, because a lot of organizations simply don't have the resource or the ability to do ongoing checks on all your vendor database, right? So you've got to take a risk-focused approach, select those vendors that you think are material, and try and build in a program of ongoing compliance. Possibly 12, 18-month cycles, but These are examples of a good vendor risk management program. So wanted to deep dive a wee bit into the privacy assurance process, right? What is it? Well, a privacy assurance process is there to identify and minimize your privacy risks. This could be associated with any new changes to process or activities involving technology, people, or process. And very often we find when we onboard or outsource to vendors, it's a combination of process and technology. And therefore, we've got to understand what that vendor is going to do for us. In order to do that, there's 4 key stages from a privacy vendor risk management perspective. The first stage is your due diligence, where you would design a third-party questionnaire, ideally in collaboration with your friends in security and other compliance programs, such as your sanctions program or FCPA ABC, so that the vendor isn't inundated. But plus, it'll give your organization an overarching view on the risk threshold from that vendor. In particular, you want to understand the data flows, right? Flowing from that data flow, you'll be able to understand what the vendor is going to be doing for you. And thereafter, you can decide on a risk-based approach whether you'd like to do a triage or further triage. And this can be linked to things such as your records of processing as well, so you can fully automate your process and enable you to scale. And then, of course, all of us are sort of familiar with data privacy impact assessments. They are quite ubiquitous in lots of data privacy regulations. And these should be performed where necessary, including the LIA. So the key takeaways today, folks, are understand the needs of your business and take a measured approach to vendor risk management from the privacy perspective. Ensure that you have a reasonable VRM process, and it includes privacy assurance and is totally cross-functional. And please manage your risks. Thank you very much. I hope I'm on time, and I hope you enjoy that.
Darryl, you're perfectly on time and perfectly clear from your presentation. Thank you very much. It was very well structured, and I think if you could share this presentation with our attendees, I think this will be a great takeaway from this Congress. Thanks again for your participation. Nice to meet you. Hopefully not the last time. So let's be in touch.
Thank you.
Thank you all.
Thank you very much.
Thank
Bye.
you.
Bye.
Thank you. Bye-bye. We are moving to our next very special speaker, Filiberto E, a legal advisor to the Vice President from the Italian Data Protection Authority. Filiberto, this is our great honor to welcome you on this Congress. Thank you very much for participating. And we look forward to your presentation. And I know that Christina also wanted to say a couple of words.
Yes, thank you, Irina, Filiberto. Thank you very much that you, in this short notice, almost for 1 week, accepted our invitation and found the time to participate. It's really great honor and pleasure for our side. And our Congress is a union of different communities and associations all over the world. And for us, it's a great important aspect that such experts as you are participating also in this Congress, and you maybe give us some support by your participation, and we really hope that our community of different communities will live for a long time. So Filiberto, also after your presentation, we will have coffee break and networking with our speakers. And I really want to invite you to this networking and all our speakers, maybe to discuss some topics. And let's get started. Thank you very much.
Yes, I will also introduce that Filiberto will talk about the modernization of Council of Europe Convention 108 and the importance of ratifying it, which is very up-to-date topic for Russia. So thank you, Filiberto, and the floor is yours.
Thank you very much. Good morning from Rome. Now, I hope not to disappoint you after all these wonderful words. And let me, first of all, thank the organizers of the Eurasian Data Protection Congress for giving me the opportunity to participate to this outstanding event. I am sincerely honored to bring you the greetings of the Italian Data Protection Authority and to share the stage with so many distinguished participants and speakers.
Okay,
so,
thank you.
For the next minutes, I would like to talk to this international audience about a legal instrument which goes far beyond the EU borders, which is actually unfortunately neglected, but that can be instead quite relevant for all our jurisdictions, having the chance to represent a viable tool to facilitate international data transfers while guaranteeing an appropriate level of protection for individuals globally. On the 28th of January 1981, already 40 years ago, the Council of Europe opened for signature its Convention for the Protection of Individuals with regard to automatic processing of personal data, more commonly known as Convention 108. This convention remains to date the only legally binding multilateral instrument on the protection of privacy and personal data open to any country in the world. Convention 108 currently counts 55 state parties, 8 of which that are not from the European continent, and its committee also welcomes the participation of over 25 observers. And it is chaired by a very distinguished colleague of mine, Ms. Alessandra Perchierucci of the Italian Data Protection Authority. This committee forms a global forum of over 70 countries working together on data protection. Convention 108 has been modernized in order to adapt this now 40 years old instrument to the new realities of an increasing connected world and to strengthen the effective implementation of the convention. The protocol amending Convention 108 was opened for signature on the 10th of October 2018 in Strasbourg and has since been signed and ratified by numerous countries. Once it enters into force, the amending protocol will deliver several essential objectives, notably respecting human dignity and integrity in the digital age, facilitating data flows and strengthening cooperation between supervisory authorities. Convention 108 plus, then, as the convention is named when amended by the protocol, is seen to become the international standard on privacy and data protection in the digital age and presents several advantages for countries ratifying or acceding to it. Convention 108 plus is the only international instrument with a sound potential to become the global treaty on the protection of privacy and personal data. Recognizing its unique potential to become this global instrument on data protection, the United Nations Special Rapporteur on the Right to Privacy, Professor Joseph Kanatachi, has recommended to all UN member states to accede to Convention 108 plus in 2 of his reports already. Convention 108 has been constructed around 2 main objectives: guaranteeing an appropriate level of protection for individuals and facilitating free flows of data among state parties and beyond. With its balanced standards, Convention 108 plus sets a commonly agreed level of protection that an individual should be guaranteed in the digital age in order to safeguard her or his dignity and fully enjoy her or his right to informational self-determination. Among principles and provisions of Convention 108 plus, we therefore find necessity, proportionality, purpose limitation, which are applicable since the 80s, together with some new provisions such as increased transparency, meaningful accountability, new generation of data protection rights, enhanced data security, and strong oversight authorities, which are becoming highly relevant, notably because of the increased use of emerging digital technologies and also because of the intensification of cross-border data transfers. In recent judicial cases where courts have been invalidating international transfer agreements or mechanisms because of the insufficiency of the protection afforded to individuals, Convention 108 plus, notably fully consistent with the data protection framework of the EU General Data Protection Regulation and Law Enforcement Directive, can effectively contribute to the convergence towards a set of high data protection standards globally. In respect of cross-border data transfer, what deserves attention in the dualistic approach of Article 14 of 108+, which on the one hand could possibly provide for the creation of a common legal space where data can flow freely among state parties to the convention, and on the other hand, could provide for the development and implementation of tools and standards, such as ad hoc or approved standardized safeguards, to ensure the appropriate level of protection also in the case of data exports from state parties to non-parties. Considering what we have learned from the pandemic experience in terms of importance of massive data sharing at a global scale, and also the global repercussions of the latest decisions of the European Court of Justice on international transfers, the notorious Data Protection Commissioner versus Facebook Island and Maximilian Schrems, the relevance of Convention 108+ can only grow stronger in light of the sound, protective international regime that it provides, acting as a bridge between legal regimes and continents to facilitate data flows to safe destinations. Significant provisions can be found throughout the Convention, showing the flexible, malleable connotation of principles that can be therefore easily adapted to the different legal cultures and systems they are addressed to. Just to name few important ones, the first is the choice of a simple system of legal basis for the processing of personal data founded on the recourse to either unambiguous consent of the data subject or to some other legitimate basis laid down by law, which therefore leaves to the national legislators discretion to decide on more legal basis, taking into account national specificities and the suggestions coming from the explanatory report which accompanies the text of the modernized convention. Secondly, another important example is the protection against unlawful use of exceptions provided for by Article 11 with regard to the processing within specific sectors, such as law enforcement and national security. In such delicate fields, this provision can become a standard to ensure that the achievement of important public interest should be accompanied by the respect for the essence of fundamental rights and freedoms, as Article 11 itself explicitly states. And finally, paragraph 4 of Article 10 leaves to the state to adjust the accountability requirements according to the context of the processing. They are flexible standards, as we can see, but still ensuring a high level of protection. It is not by chance that at the European Union level, where transported data flows have an articulated and strict regime, it is stated clearly by Recital 105 of the GDPR that the accession to Convention 108 of a third country must be considered as an element that should be taken into account by the Commission in the adequacy assessment of the third country. States parties to Convention 108+ plus commit to a mutual cooperation in order to ensure the highest level of data protection as well as compliance with international standards. The ruling of 16th July 2020 of the Court of Justice of the European Union on the Schrems II case, in which the court invalidated the European Commission's adequacy decision underlying the EU-US Privacy Shield arrangement, will also present us with several opportunities for this convention. A, opportunity to the Council of Europe more broadly to set up standards for the processing of personal data, also in the fields of national security and defense matters. The Statute of the Council of Europe provides the necessary material and territorial scope of action needed for this important work. And B, opportunity in bringing more precision on how to implement in practice the necessity and proportionality conditions required for the access to data held by private companies from public authorities. And more importantly, how to ensure that in a cross-border data scenario, all recipients in the receiving state guarantee an appropriate level of protection that is a precondition for the transfer itself. Belonging to the Convention 108 Plus Club also means being able to rely on a strong network of peers capable of providing assistance, advice, and support. In an era of increasing digitalization and globally shared challenges, the Convention allows the competent data protection authorities to work hand in hand. Accession to Convention 108 Plus implies the recognition of an international best practice and opens opportunities for further enhanced cooperation, including through joint investigations and joint regulatory actions, for which the Convention also provides the legal basis at international level, which is another unique feature of the Convention. I would like to end my intervention by underlying what is the challenge. The challenge would be to have the prompt entering into force of the modernized convention, reaching the needed number of ratifications, 38 by 2023, would allow the entering into force of an updated, unique, legally binding instrument at international level for ensuring the protection of personal data. After 3 years from the opening to signatures of the protocol amending 108 on the 10th of October 2018, having reached a number of 14 ratifications seems to indicate that in order to achieve this goal, we need to accelerate in all remaining state parties the signature and ratification process. The Italian presidency of this committee has this as key action. And a maybe longer term challenge would be to increase the membership of the modernized Convention 108 up to at least 70 country parties by 2025. The full potential as global data protection instrument would only be unlocked if a maximum number of UN states would join it. For these, we need all to intensify our efforts. Thanking you very much for your attention. I greet you all with warm cordiality, warm Italian cordiality, and the hope of being soon able to meet in person.
Oh, thank you very much, Filiberto, for your so careful, so emotional, and so professional speech. I really just while you have your topics and some links for my friends and colleagues to take you as maybe some a good example of a speech, to be honest. And if you have maybe 5 minutes, yes, I'm really grateful. And I also want to invite our today's speakers to participate in some communication discussion with you if you are not if you like it, and my people dear speakers, just join to our communication session and you are free to ask your questions if you have any. So Filiberto, for example, Russian Federation is a list of countries which are at the ratification stage of a new modernized convention. And for example, let's begin from our country, because among our partners of the Congress, there are a lot of countries which are not in the list of countries with adequacy decision of European Commission. So after the case of Schrems, we, as you know, have a lot of questions, and our consultations and experts have different positions regarding, for example, transfer impact assessment, which should be performed when you use, for example, standard contextual clauses. And in case when company, for example, from Italy, plan to transfer personal data to Russia or another country which is not in the list, and they want to use standard contextual clauses as legal basis for data transfer, on what main aspects will you concentrate your thoughts and your maybe on what main aspects will you take into account when analyzing the legal basis, and what main aspects are important when you perform transfer impact assessment? On your opinion, you just can share your opinion as a representative of DPA or as expert. It doesn't matter. We just want to know some maybe advice from your side. Thank you very much.
Thank you. And let's say that from now on, I will speak as professor of data protection law in a university. So as they will be just my personal opinions. As you know, the GDPR, the entire asset of our data protection law regime, is focused especially on granting to data subjects full dominion, full control over their personal information, over their personal data. So all the actions regulated by the GDPR and by the other soft law tools proposed and provided by the European Data Protection Board are aimed to grant this principle and to strengthen the possibility to do that when data subjects become more vulnerable. Of course, when their personal information, when their personal data are transmitted elsewhere, are transferred far from them, their control is loosening. That is why we want to focus on that. Those standard clauses must not act as mere formal instruments. They must be effective. I think, to answer to your question on what we have to focus to grant that, it is granting European data subjects the full control over their data, even when they are transferred to Russia, for instance. This was the problem with the US. You know, the GDPR operates around some magical words: accountability, privacy by designs. They are all formulas that instead hides this very substantive approach, this risk-based approach to grant data subjects control over their data. We wanted, when we passed the GDPR, to allow our European citizens to have their safeguards traveling together with their data, also beyond the borders of the EU.
Okay, thank you very much for your answer. Yes, I understood the approach, but in case you mentioned, for example, full access of data subject to their data and also their control of their data. But in case if, for example, one company transfer personal data of employees, and she should done this because legislation in her mother company requires this data for example, some compliance issues. And this case on GDPR side, processing of personal data of employees is restricted under consent, for example, in case of some not freely given issues. But yes, but there is requirement for mother company, and our clients, for example, I'm also working in KPMG, are wondering what should be done by mother company, because without this data, they have some fines from supervisory authority in another, not privacy in another aspects. And what can you advise in this case?
In this case, from what I saw also in the several discussions within the EDPB, in the merit of concrete cases, I think that the key there is in transparency. In this case, at least the data subjects must be aware of it. So when it is impossible or there are restrictions to allow them to exercise an effective control, in this case, I think that everything must be recovered with this balancing on the transparency side.
Yeah, thank you very much. Yes, I think the same, that transparency and risk-based approach will help our data controllers and data processors during their operations. And I have one more question. Do you have a time?
Yes.
Okay, no, it was not this question.
I'm here for you.
Okay, thank you very much. When your time will be ended, just tell me, and you can go to your work issues. So we have a question in our chat in YouTube broadcasting regarding European Commission decision on standard protection clauses. There appeared exception under Recital 7. Could you please detail where there exists transfer in situation where the controller is in the third country and processes data?
Actually, Christina, we are still interpreting this rule. It is still at a stage of interpretation, and all the several European DPAs are providing their personal reading of this statement. So at this moment, I have the same confusion that every other stakeholder have in front of these provisions, since it is still under discussion on the real interpretation to be given to it. I'm sorry not to be able to answer precisely to this question.
Okay, but I think that your answer is also an answer, because there is some negotiation about this aspect. So, dear speakers, I promised you that you will have an opportunity to ask also your questions, and among our speakers are representatives from another communities and associations. Maybe you want to ask your question to Filiberto, or maybe Diana, or somebody from you who wants. Dear speakers, if you do not have question, we can free Filiberto. Selin, do you have question? Please unmute your microphone.
Yeah.
Yes. Okay.
I would like to thank you, Filiberto, a lot for the presentation. As a speaker from Turkey, Convention 108 is very important for us, and in the process, we are also as Turkey in the process of joining the Plus Convention 108 Plus. But I think, as he mentioned, it was very important for all countries to understand the meaning of the convention and its possible effects going forward for international data transfers. I want to ask him the question whether he sees really this being a very efficient tool also for the interpretation of the new standard contractual clauses, and the countries, especially when they are processors in third countries like Turkey, their compliance with the requirements. I think it is a very important tool, and he mentioned, but I'm a little bit more curious about how we can use it as a more efficient tool going forward.
I do, Selin, I genuinely do. And I think, and also in this case, it is my personal opinion, that these must be the key for the EU to look eastwards. Perfect. These can be actually what, how can I say, it is the real bridge for an effective Ostpolitik in data geopolitics. We live in a data flows connectography system.
That's very true.
And we cannot, I think, remain trapped, locked in within our very exclusive borders and very privileged borders. We have to look beyond. And these can really be an element to approach others and to be approached by others.
Thank you very much. This is really helpful. Thank you.
Thank you for your question, Selin.
Thank you, Filiberto. Also, we have a question by Diana. Diana represents the association from Moldova. And here was Selin. Selin represents an association from Turkey. So there are a lot of countries. So Diana.
Hello. Thank you once again for your presentation and for your...
Diana, sorry. Could you please speak more loud? Yeah.
Okay, I don't know, today I have some issues with the sound. Now it's okay? Do you hear me?
Yeah.
Okay, well, my question is regarding the processing of employees' personal data, but in the context of COVID. So what is your opinion when the employer have to take temperature measures, or I don't know, the status of vaccinated, non-vaccinated employees and so on, because different countries have different approaches to this. So it's a very dilemmatic topic, but in the same time, there are a lot of questions in this regard. So what's your point of view?
Yes, indeed, Diana. This is a very tricky question for me, since, as you said, there are different regulation about this topic. And as you may know, Italy had chosen to follow a path which is one of the strictest ones. Now in Italy, digital green certificates are necessary not only to go around. They're not just an instrument for free movement, but now they are mandatory also to access within entertainment places, restaurant, bars, but also to have access to school, universities, and working capability, places. The Italian Data Protection Authority has provided several measures to mitigate the extremization of these data collection, but still gave a positive opinion to the law, to the national law prescribing and implementing those measures. So in the end, we have, especially in this time, to act as a balancing arbiter. This is the role for Data Protection Authority now. It is not an easy task at all, I can assure you. We are trying not to be seen as an obstacle. We want to facilitate, we want to accompany citizens during these tough times, but our task will remain the one to protect a fundamental right. So it is not easy at all to contemporate necessities of public interest and the general protection to individual rights. It is the task of the century for us. It is not easy at all. I know I did not answer you precisely, but try to read within the lines.
Just to emphasize.
Oh, no, louder.
Louder, please. Louder, please.
Sorry. Just to emphasize, if there are some legal obligation for the employer, so it's allowed to.
Yes, yes. We focused a lot. Very good, Diana. Yes, we focused a lot on the existence of an effective legal basis. We wanted the law, the regulation to be very clear on the purposes, the means, and also the storage limitation of the processing. This was the condition for us to accept this.
Okay, thank you.
Yes, you are right. Thank you.
Okay, thank you very much, Filiberto. And if you want, you can stay with us here, but I can ask you some additional questions because we really have time for you, and I can take your time, not pledge for this Congress. And thank you very much, very much. And we are all who see now your presentation admired and inspired by you. You're so interesting person. Thank you. And we are really be happy if you also will accept our future invitations, because your style of speaking, it's gorgeous.
Thank you very much.
It's really gorgeous. I really inspired by you. Yes, we had, for example, yesterday is the first day of Congress, and we had 1,000 of listeners. And after this day, I really very tired. But after your presentation, you really have a lot of energy. So thank you very much. And if you want, you can stay with us. But if you have your issues and deals, thank you very much.
I'm very pleased, and let's hope to have further chances to connect and to talk about those very important topics.
Yeah,
thank you.
Of course, let's stay in touch, and thank you very much. So, colleagues, as I promised you also, we will give the word to, yes, 1 second, he's here. Petros, are you here? Petros, I promised you for continuous of your presentation, and you can continue because your presentation about gaming industry is really interesting, and we have also a lot of questions if you have time. So you have 10 minutes, and dear colleagues, speakers, you are free to ask your questions also to Petros, because we have networking communication session. And Petros, looking forward, I also want to transfer the question from my colleague about what main issues, privacy issues, should take into consideration gaming industry, the companies from gaming industry. What main issues and differences do you have? And take your word, and thank you.
Thank you, Christina. So perhaps this is the biggest challenge that the gaming industry is facing currently, and it has to do with youth protection, how to treat and handle minors' personal data. We saw a development, development for different EU member states in regards to the regulation of minors when using online services. While this was long before in the US and also in South Korea, we saw the last year regulators tending to regulate the inappropriate or harmful content of online services, requesting from organizations to take the appropriate measures to protect children from that content. I will begin with German Youth Protection Act. We saw that this year, actually on May 2021, they have reformed their Youth Protection Act to cover also the online services. The German Youth Protection Act is not like the rest of them, which are very broad and general in nature, but they specifically target certain risk activities that they deem harmful for minors. And this is when minors are interacting with adults online, like communication tools and features available in the games, payment transactions, advertisements which may advertise products which are not suitable for minors, and all other risk activities that they see as harmful. They reformed and also they proposed some amendments to the current regime to cover, for example, micropayment transactions and loot boxes, which of course is the hottest, it's a very hot debate in the gaming industry, whether it is classified as a gambling or not. They also, it's up to, they take a risk-based approach, definitely. And they would like to see organizations together with private bodies like the age ratings bodies to adapt suitable descriptions and be more transparent in terms of how they treat and handle, how they actually, the features, the in-game features work, how they process personal information, what kind of harm they may produce, and so on. Everything, of course, it's about transparency and be open and clear with the users. We have also the UK Age Appropriate Design Code. This is actually a groundbreaking code. It was released last year from the UK Information Commissioner's Office. It sets out 15 standards, 15 principles, which organizations should take into account when designing services. For example, they should consider to embed or integrate data protection principles and other safeguards that will ensure the protection of children when using their online services. To name a few, first and foremost, the most important principle is that of the best interest of the child, which is found in the UN Convention rights of children, which it should be the primary one, and everything that should be designed for the children should be for their best interest. Of course, other principles which relate to the age appropriate design code is the age appropriate application, which relates to ensuring the age of the users to adopt age assurance mechanisms like age verification, age estimation, account confirmation, for example, or self-declaration, allowing children to declare how old they are in order to take the appropriate measures and comply with the principles laid down in the code. They also have nudge techniques, which they provide that minors should not in any way encouraged or manipulated in a way that it will be detrimental to their against their interest. Also, we have minors regulation in China and South Korea. South Korea, it was one of the first countries that they indeed regulated the use of gaming for children. They restricted the use of playtime, of gameplay, and they also introduced parental controls on spending in-game purchasing. This year also we saw China, which has introduced some very strict measures in terms of allowing minors to play for a certain period of time during specific days and times during the week. We have also US COPA, which is dated back in 1998 and aims to protect children below 13. for those organizations that they have actual knowledge. All their services are directed to children and they collect personal information. Therefore, they need to comply with the requirements as provided in the US COPA, like verifiable consent, parental consent, be more transparent in terms of how you collect, share, transfer the personal information of minors. Germany and UK, we are not the only ones. We have also France, Sweden, Netherlands, Norway, and Ireland, which they have introduced their own codes regulating the use of online services by minors. Of course, the UK Age Appropriate Design Code is the most comprehensive one. And all the rest of the guidelines are more or less on a similar, they have similar philosophy. And also France, which they publish 8 recommendations on how to treat and handle the personal information of minors. They make reference to the UK Age Appropriate Design Code. I am aware, as they also published it online, that CANIL is working now to get a more comprehensive code on how to design data protection safeguards into online services when those are used by minors. So overall, the aim of those regulations and codes that are published by the regulators is to limit and restrict the exposure of the minors to risky activities. For example, to inappropriate or violent content, excessive spending, gameplay time, which may lead to addiction, for example, aggressive monetization techniques, which minors are not aware how algorithms work actually, and they may be induced to purchase an item, manipulation techniques, dark patterns, which again relates to encouragement, manipulation techniques, or how to lead the user in a specific way that you would like him to take a specific action, to lead the behavior to your for your benefits. And also, of course, communication features, which it is to be considered by many as a very high risk activity, especially under the German Youth Protection Act, which makes specific reference between the communication of minors and adults during the game.
Petros,
yes.
sorry.
Sure.
We have also limited time. Yes, only
Yes.
1 minute. Sorry for interruption. And as I understood, you have a lot of tasks and responsibilities on your position of data protection officer. And let's discuss main topics. Thank you very much that you really shared your opinion during these 10 minutes. It was quite useful. As I know, you will participate at DPO session at 4 o'clock at Moscow time, and we are waiting you at this session. And in case if you didn't share with us another topics of your presentation, let's share it. And so a lot of work by your side, so really.
I finished, that's it. That was the most challenge and key development in the gaming industry. Thank you very much. Just wanted to highlight the specific developments and challenges on youth protection. Thanks a lot, Christina.
Okay.
Thank you for your time.
Thank you.
Thanks a lot.
And I want to introduce another speaker, Punit Bhatia, CEO and data protection expert, Fit for Privacy Board member, DPO cycle also of artificial intelligence and privacy, and be ready for GDPR. Punit, hi.
Hello.
Yes, I see you, hear you, and see your presentation. Check your floor, and let's begin. Thank you.
Thank you so much. As we have about short time and we want to keep the presentations focused, so I'm going to focus on AI and privacy and how to find balance. Because when we talk about AI, we tend to think of a lot of new things, a lot of possibilities, a lot of data hungry elements. And when we think of privacy, we usually tend to think like it's going to be restrictive, a lot of laws, a lot of don't do things. And the question then becomes for us as DPOs or even as management is, Are we in for something which is related to each other, or are these two things competing with each other? That is, are these friends or are these foes? And that's a question I'm going to handle because there's not an easy answer. But before I get there, I'd like to say thank you for being here, for everyone who's live and everyone who's watching the recording later on, because we appreciate that you take time out of your busy schedule and watch these presentations and these conferences. And also I'd like to thank Christina and her full team who have taken this effort of organizing this conference and making sure you can receive these materials and we can present these materials to you. So thank you so much, Christina, for your efforts. So as Christina already introduced me, so I'm Punit Bhatia, and let's get back to the topic. AI and privacy, are these friends, are these foes, and how do we find a balance? So let's first understand at a very high level. I know we have had a lot of expert speakers talking about a lot of things, but let's look at the highest perspective. Few years ago, when somebody was clicking our photo, we had the choice. We had the choice to say, no, I don't want to be clicked. And that little choice, that is choosing what I share with who, is called privacy. So privacy is as simple as having choice. That is choice about what you share with who. But the question is, choices are complex. Do you choose a pink or a blue? Which drink do you choose? And every one of us has a different flavor for coffee, and some of us don't like coffee. That means if these choices are difficult, privacy as a choice is also going to be difficult. So who decides what is right and what is wrong? And that's where we have privacy laws coming in, because privacy laws help us with rules for processing of personal data. So on the privacy side, the story is there are rules, there are laws, and those rules or laws help us what to do and what not to do. But when it comes to AI, it's more greenfield. There are some frameworks and AI regulation is coming in the EU, but other places we are just having a conversation. Should we have a regulation? Should we not have a regulation? And then it's a match of two areas. In one, we have very clear legislation, but in the other one, we don't have. So how do you manage these scenarios? But what we need to remember here is we are talking about data, because we're in the digital world. So everything is data related. And when it's data related, some of that data is personal data. While we can explore, innovate, and do whatever we want to wish, that's fine with data. But when it comes to personal data, then we are touching people like you, people like me, people like all of us. And we need to treat that data, that is data relating to you and me, with respect. And that's where the challenge becomes. So to address that challenge, I'm going to propose to you three solutions or three broad areas in which I usually recommend when I work with people. First thing is, look at these kind of projects which involve AI and privacy from a very broad perspective. Now, what does broad mean? Broad means, in my language, 6 things. First, look at what does the law say? Are there any limitations? Are there any exceptions? Are there any things that are allowed? Then look at it from privacy perspective, meaning, is this what we're going to do reasonably private or reasonably transparent for users? How would their privacy be impacted? And then look at it from human perspective. Now that's more difficult saying, because if you're thinking from business perspective, it's always good. But if you think, would you like to offer this solution to your daughter, to your wife, or to your mother, or to your son who's a teenager? Then think from that human perspective. And another thing is, choose between ethics. It may be ethical, but it may not be ethical. And that's a difficult question, because you have to choose between what is right and what is more right, or what is wrong and what is more wrong. And that's always a difficult choice. And then monetary, of course, it's a business that you are running, and that's why you're doing projects. You got to look at things from monetary perspective. And then society, because what people will expect in Netherlands and what they will expect in Russia would be very, very different. Some societies have a different culture and others have different culture. So look at your project from these 6 perspectives. And when you look at it, you'll have a 360-degree perspective. And then you can make holistic decisions. Typically, what I see is organizations look at it either monetarily or legally. Well, that's a good start. But if you include privacy, human ethics, and society, you're going to have a generic perspective. So one first thing that I look with my clients is I ask them to look at things holistically, broadly. Second thing is I usually talk about few things to do. I will also talk about few things not to do, but first a few things to do. Have a policy, have a strategy, have a framework, because you don't want to operate in, what do you say, isolation or with abundance. You want to have clarity. What is your strategy? What do you want to achieve? And what are the things that you want to permit? So maybe have some principles or guidelines. Then set up some governance. If you're having privacy and AI projects, you don't want things to be decided and then management being surprised. What you want is projects coming in, getting approved and getting clarification, and you having the opportunity to ask questions. This means you got to set up a dedicated team or department who would take care of organizing this governance, defining this policy, and overseeing the projects on your behalf. And if that's the case, you got to train your staff about what your strategy is, what you want to achieve, and what is the strategic direction you are on. If all that is needed, it would need investments. Yes, over and above your projects, you'll need to set aside some investments so that you're doing the right things in the right way. This would mean you would need to create a secure infrastructure and ecosystem in which failure is appreciated. Yes, I'm not talking about success, I'm talking about failure being appreciated as well, which means you don't want everybody to be entrepreneur, but you want them to be intrapreneur, that is within the company, have a mindset which is open to new ideas and opportunities. If that is needed, you will need open and proactive communication, that is transparently, yes, this will work, yes, this will not work, let's try out. And when you try out, you will leverage your investments and efforts because you will find the results up early. And as you do that, you don't want to stay in silo mode thinking about your company. You want to have outside in perspective, that is look at what the market is doing, what has been done, and learn from that rather than having to create your learnings all the way. So if you do these 10 things, keep those 6 perspectives, still there are a few things not to do. And when I say not to do, meaning things that you don't want to do. So let's look at some of them. First is never ever rely on one framework. There's the Chinese framework, the EU framework, the US framework, the OECD framework, and so on. All of them have good points and all of them are lacking in one or the other thing. As one philosopher said, all models are wrong. I won't say all models are wrong, but I would say all models are right. So pick the right ones from each one of them. Second thing is, don't allow decision-making to be centralized and being made by one person. Allow decision-making to be federated. Let multiple people operate. Maybe the 6 perspective we have, ask 6 people to join your governance and look at things from 6 perspectives and let them contribute to the decision-making collectively. This would mean you're not relying on judgment of one person, but collective group judgment and fact-based decisions. Now, while you may think that you have done the governance, you have set up the policy, and you have the team in place, it will work. No, there will be knowledge gaps, and those need to be addressed through awareness. So do not underestimate the power of creating awareness and closing the knowledge gaps. And last but not the least, thinking that it is too much, thinking that I'm saying too many things. And when you read the regulation or law that there are too many things to do not think we will do nothing, or let's not do it, we may fail. Well, you may fail, but the cost of doing nothing is far higher than trying. So try, and when you try, you'll be successful. So in short, what I'm saying is 3 things. Look at your projects from various perspectives. And when you look at them, you'll learn and have more opportunities and options to choose from. Have a list of do's, that is what you want your teams to do. It starts with a policy and a framework, but you can add a few more things. And also give your team with a list of don't do's, very clear things. If it is impacting people, if it is going against human rights, if it's going against transparency, we don't want to do it. So give them clear direction, and then your AI or privacy and privacy, all these projects will not look like competing against each other, but following a clear path. I won't say it will be easy, but it will be easier. And that's my message. And last but not the least, remember that data is considered personal and you've got to protect it. And especially when it relates to individuals like you and me. And when it relates to individuals like you and me, we got to respect the data. Like we say, respect the humans. That's my short message. So thank you so much for your attention. And I think I've probably saved a couple of minutes for some questions. So thank you so much. And if you want to connect with me, feel free.
Thank you very much, Puneet. And really, you have interesting feed of information. I think that like privacy, fair trial, and you're so amazing speaker. Thank you very much. And as for me, as you talk about how to balance artificial intelligence and privacy, for example, in Russian Federation, we have a lot of activities connected with artificial intelligence. And could you please share in your country what main requirements regarding artificial intelligence and maybe main aspects we should take into account while thinking about in combining these two streams? Just we have 2 minutes. Yes, maybe you can shortly answer.
So I'll give you a short perspective. So we have in the EU, because I'm in Belgium, so in the EU, and Belgium is part of EU. In EU, we have the EU GDPR, which has its own principle, and now we're coming up with the AI regulation. What is good and common amongst the two things is there are some principles like transparency, that is, be open about what it is and how you're going to do things. Second is it's about trust and being responsible. So don't do something just for the business. Put yourself in the shoes of a customer, consumer, individual, and see if that's a viable thing. And more importantly, be ethical. If, as I said, if you won't give it to your family member, if you won't do it for your family, don't do it for your business. That's at the highest level. And of course, there are limitations around what you're saying in transparency. Follow that. Do not do, and also ask for consent. Consent, again, we'll refer it to choice, and choice is privacy, as I said. So if we look at that dimension, if you're giving users a choice, telling them what you will do, being responsible, being ethical, and most importantly, being accountable. That means you can demonstrate what you're doing with a track record that you had good intentions all the way. Then good intentions will result in good results as well.
Okay, thank you very much for your recommendations, but in some cases they are so easy, but not so easy for implementation. And Puneet, thank you very much. And in case if my colleagues from artificial intelligence stream will be also considering to organize some congress, I also will ask you to join us. Thank you. And I want also to yes, John, I see. Thank you very much, Puneet. And
with pleasure.
And we move to our next speaker. It will be Ibrahim Hassan, lawyer and director of Act Now Training from UK and UK qualified lawyer. And Ibrahim will tell us about UK privacy approach. And from my side, I want to add that if you are Russian-speaking audience, you can also see the presentation by Janis Sadovnikov, yesterday presentation. Janis also tell us about UK law, and I think that Ibrahim will also share with us a lot of important aspects. So take your flow and let's start it.
Thank you very much, Christina, and thank you very much to all the organizers for organizing this wonderful event. I have been to Moscow, I must admit, quite a few years ago now. It would have been nice to visit face to face, but here we are virtually, maybe one day. Thank you anyway. Yes, my name is Ibrahim Hassan. I'm a UK qualified lawyer and director of Act Now Training. We started 20 years ago delivering training and consultancy on data protection and privacy legislation here in the UK. UK, and now indeed we train all over the world on all sorts of privacy legislation. And with our background of 20 years, we've seen privacy law and privacy legislation very much develop here in the UK, but now we see that GDPR, or as we are working, the UK GDPR is very much now the standard which is being applied across the world in similar legislation. So it's nice that those of us who've been around since the, and I'm giving away my age now, the Data Protection Act 1984, we're seeing the messages that we've been talking about for the last 20 years, they're now sort of being repeated across the world. So that's just nice to know. The purpose of my presentation today is really to talk about the UK privacy approach, which legislation applies, and what are we seeing in terms of, in the UK, people's appetite for privacy, for enforcing their rights. And I think especially colleagues joining us from other parts of the world where the legislation may not be so old, or data protection legislation is very much in its infancy, what you can expect in the future. First and foremost, we've had a Data Protection Act for a while, but even before that, of course, the UK is a signatory of the European Convention on Human Rights, and the UK decided to implement that within UK law via the Human Rights Act 1998, came into force in, I think it was October of 2000. So even if we didn't have a data protection legislation, we still have, and will continue to have, despite what our current government is saying, a human rights culture because of Article 8, the right to privacy. I'm sure you're all aware that enshrines privacy, and because of the Human Rights Act, that's actually part of our law. So normally with a convention in the UK, it's not directly enforceable. With the Human Rights Act 1998, all the convention rights, including the right to privacy, has become part of our law. So any individual can sue any organization for a breach of privacy. So that's our starting point. Of course, in terms of data protection legislation, a little bit of, excuse me, background. We've had the Data Protection Act 1984 that only applied to primarily to data which was on computer. Back in those days, some of you may remember, there were very few computers, and of course their power to process personal data was very limited. We updated the legislation back in 1998. Data Protection Act 1998 came into force in March of 2000. And then of course we had GDPR. Now at the time, of course, we were part of Europe, we were part of the European Union. And so GDPR, being a regulation, had direct impact within the UK. No need for any implementing legislation. Then in our wisdom, we decided to go our own way. Brexit happened. And despite most of us predicting that we would vote no, we actually voted yes. And hence the UK came out of Europe. So our legislation needed to be amended. And so what we did was we made the GDPR part of our law, but we amended it as well. And as a result, after the transition period, we now have the UK GDPR. So the UK GDPR is primarily now the legislation which is used in order to protect individuals' privacy in terms of the way their information is being used. And as we know, just like the EU GDPR, UK GDPR not only applies to controllers and processors within the UK, but also has an extraterritorial effect. So the likes of Google and Facebook, but even other companies based in Europe offering goods or services to UK residents would also have to comply. The difference between the UK GDPR and the EU GDPR at the moment is very minimal. We've taken the opportunity as a result of Brexit to take out some of the EU terminology within the EU GDPR. So of course, we no longer refer to union law in our legislation. We talk about domestic law. We don't like to be fined in euros. We like to be fined in sterling. And of course, some provisions have been deleted, but in effect, the UK GDPR is very much similar to the EU GDPR. And of course, not forgetting that because a lot of our organizations, our universities, our private companies also deal with EU residents' personal information. So they are also caught, in addition to the UK version, by the EU version as well. And that's going to be interesting going forward because, of course, and I'll briefly mention it at the end as well, the UK government is currently consulting on changing the UK GDPR to make it more business friendly. Of course, that may well have an impact on the adequacy decision made by the EU in terms of our legislation, but also it will have an impact in terms of organizations that have to comply with both legislation. If the legislation departs and it's no longer the same, then there will be some conflict there that we're going to have to deal with. Of course, in the UK, we've taken advantage of all the powers to derogate from the GDPR, and we've done that by producing and passing the Data Protection Act 2018. So unlike in some parts of Europe, in many parts of Europe, you're only dealing with one piece of legislation. In the UK, we are dealing with two. So we have to consider the UK GDPR, but some of the provisions, for example, exemptions to the rules aren't to be found within the UK GDPR, they're to be found within the Data Protection Act 2018. There's also certain provisions you will find in there, such as when organizations are processing data for law enforcement purposes. So we end up, in our law, we have to look at two pieces of legislation to find the law relating to the protection of personal information. So that's sort of our landscape. In terms of how things are going, of course, we are now fined in euros. The Information Commissioner here has issued, I think it's 4 or 5 fines so far. And it's fair to say there have been no great surprises. They've been around security, lack of security around personal information. This seems to be the focus point at the moment within the UK, whereas, of course, in other parts of the EU, there have been enforcement action for breaches of the rights, also breaches of the other principles, storage limitation, failure to do DPIAs, etc. So the first fine issued by our Information Commissioner, soon to be replaced, was to a company which had stored medical information, which at the time was approximately 500,000 people's information. This was a pharmacy selling drugs, selling medicines to the public, and they had stored this information at the back of their warehouse or back of their pharmacy. Initially, they were fined £275,000 because it was left there for anybody to see. It wasn't secure, breach of the 6th principle as well as Article 32. Interesting this, that in August of this year, the company actually appealed the decision. The upper tribunal, which is where the appeal goes to, the upper tribunal here decided that that was justified, the fine, but not the level, and it was reduced to £92,000. But everything else was familiar and was considered to be correct by the appeal tribunal. The usual story, failure to comply with policies and procedures, not having people in place to deal with the issue, not having training and awareness, etc. So that was the first fine, and really after at least 2.5 years, that was felt that that was something that sort of raised the awareness of privacy and data protection, not just amongst organizations, but also amongst individuals as well. Then we had the British Airways fine, 20 million euros for a cyber attack. 500,000 customers' details were compromised as a result of lack of security. Interesting in this case, those individuals, or many of them, joined a class action because under our Data Protection Act 2018, as indeed under GDPR as well, individuals can sue for damage or damage and distress if their data has been processed in a way which is not compliant. So I believe the case was settled. So that just shows that people are much more aware of their rights in this area. Another one, £18.4 million, Marriott Hotels, actually an American company, but of course they are processing UK residents' information. Again, lack of security. Other cases that we've had, we have a company called Ticketmaster, and you have other similar such companies across the world, and they allow people to book tickets for concerts and shows and sports events. They were fined by the Information Commissioner £1.25 million. They a cyber attacker was able to use their chatbot to access information, names, payment card details, etc. Now, interesting with this one, the commissioner was very strict on the 72-hour time limit and decided that there was no excuse, that it was over Christmas, there was nobody on call, nobody dealing with this issue. The commissioner, for that and amongst other reasons, the commissioner decided to issue the fine. And we've had our first fine on a charity. So far, they've been private companies. This is a charity called Mermaids, helping people transitioning, and they suffered a data breach. An internal system allowed personal data, in some cases very sensitive health information, to be accessed via their website. And it was available for quite a while through search engines. They were fined £25,000. So all these fines are actually increasing people's awareness. And what we're seeing is more and more people willing to take action. But the privacy landscape in the UK is not just about data protection legislation. Of course, we have the European Convention on Human Rights. We also have another tort called misuse of private information. Those individuals, and I'll let you try and recognize them via the chat function if you wish, those ladies, they used, or in the second case, it was used against her, data protection as well as misuse of private information to control the information, photographs and other information out there. So in the UK, we're not just looking at data protection legislation, we're also looking at misuse of private information, breach of confidentiality as well. And all this is leading to more people willing to take action against the media, as in this case. A television company had to pay damages to a woman who was featured on a TV program known as Can't Pay, Take It Away. This is where bailiffs, people who owe money to companies, they visit the debtor, and they had cameras, they were videoing, they made a TV program about it. The lady sued for damages using data protection, amongst other things. And the public are becoming more concerned about the Punit interesting talk that he did. He talked about AI, algorithms, of course, all that's there. Councils, our municipal authorities are using algorithms to profile individuals for the purpose of benefit claims and other things. Individuals are saying things about that. We've had concerns very recently about facial recognition in schools. So again, public are much more aware. Ring doorbells, I'm sure you have these in Russia and elsewhere. So people, there was a case recently in the county court where a lady sued her neighbor because he was using the Ring doorbell to spy on her, some would say, and to harass her. There was data protection implications there. And finally, something that I gave an interview to the BBC very recently, and again, all these stories you can find on our blog, footballers. They're using their rights under data protection to try and control the information that is out there being used by all sorts of companies, including betting and gaming and other companies. They're claiming it's their personal data. They have a right to see it and also to control what happens with it. So what we're seeing within the UK is very much...
Sorry, we have a limit time because the next speaker is on air. Yes, 13 minutes, sorry. I should interrupt, but your speech is really very interesting, and I can let you, for example, time in our section results at 15:30, and we can start for your site. Maybe you can add something about your company and about your actions as a privacy influencer, I think, because thank you very much that you come
No
to
problem.
us.
No,
And
welcome.
I really
Sorry for going over time.
Okay, thank you. And I highly recommend your blog and your LinkedIn page. There's a lot of information useful regarding privacy and artificial intelligence. And thank you that you text me and advise your help. So it was really interesting presentation, and come to us at 17:30. I will text you the time. It will be in Moscow time. Yes, we have time difference. So thank you very much. And I want to move forward to another speaker. Thank you, Ibrahim. Maria Ernst, are you here? Okay, thank you.
I am here.
I want to introduce my colleague and friend. I think, yes, you are my friend. Maria Arns. She's data privacy expert, privacy awareness manager at Vinted. And Maria will speak us about employee awareness strategy in a privacy program. And also I want to highlight that Maria has a podcast. The name, I hope you translate by your own side, because I I can be mistaken. And as I know, you also plan to perform a podcast in English, and we are really waiting for this. And after, when I maybe pronounce this, we are a lot of people who are watching us. You heard this podcast in English, so thank you very much, and take your floor. And also the next session will be at 16. It will be DPO section. And Maria, you have not 15 minutes, you have 30 minutes. And in case if you ended in 15 minutes, I will call my colleague, Oleg Blinov. He is sole moderator, and we just maybe have some small talk regarding your topics. So take your floor and let's start it. Thank you very much.
All right. Thanks, Christina. What an introduction. Regarding my English podcast, it is actually just an idea. It's not really a plan, but thank you nevertheless for the warm welcome. And thanks everyone who is now connected and listening in. I am indeed going to speak about employee awareness, and it's important. And I think this is something that doesn't really get as much attention as I think it should, and that's why this is the topic that I'm going to speak about. I have to say that the 15 minutes deadline challenged me a lot. And now I hope that I will manage to do it in 15 minutes. However, you generously offering me twice as more time now is a next level challenge for me, but let's see how it goes. All right, so I hope you can see my screen, right? Otherwise you would have told me, Christina, I assume.
Yes, it's okay. We see you and hear and see your screen. Thank you.
Fantastic. Thanks a lot. So as Christina already mentioned, my name is Maria. I have a couple of certifications that are, recognized in our privacy fields. However, I usually put them on slides, but I prefer not to kind of identify myself through them. At the moment, I work as a privacy awareness manager at Vinted. And I also, as Christina already kindly mentioned, I have a podcast that I launched and co-host with Sergei Brankiewicz, who is actually, I think he already held a presentation yesterday. If you followed, you know him already, or you might also know him from other, circles. The podcast is in Russian, which is my mother tongue. It's called Necheva Skryvat, which translates into nothing to hide. And it actually covers not compliance things around privacy, or at least we try not to talk about compliance and the GDPR, even though both of us are, compliance specialists in the first place. But it's rather about, us speaking as privacy enthusiasts, rather. And I want to also highlight that I'm not speaking on behalf of Vinted, even though it's my employer. Opinions that I'm going to talk about today are my own. Okay, so what I'm going to tell you is roughly breaking into three parts. And first of all, I really like to start with the why, specifically why the awareness, or employee awareness in the field of privacy is so important. What can be done to reach awareness, and how exactly can it be done? And notice that I'm not saying that what should be done or how should it be done, because privacy, first of all, is a very new field for the corporate world. And I don't think that there is one playbook that everybody has to follow. This is something that I suggest as an open discussion and something that I think the way things could work. But again, I'm not saying that this is the only correct way of doing things. I'm rather interested in, keeping this discussion going rather than, imposing or monopolizing this discourse and saying that this is the only correct way. All right, let's start with the why. And I love starting with the why, even though many of you, and I expect that a lot of specifically privacy professionals are listening right now or watching even, and I think you might have a feeling of like, of course, we understand why. We know that, you know, there is a compliance obligation to have awareness in place, and also we would like to have a bit more support from employees. So we want also to give them this awareness, to train them, and so on. However, I think it's very important to repeat these things and to repeat to talk again and again of why we are doing it. Because I listened to a TED talk that really impressed me, and I think many of you have listened to the exact same TED talk that says that if you want to kind of influence the way people take decisions, you need to speak to part of the brain of theirs that takes decisions. And apparently, that's a part of the brain that is much older. I think it's called limbic brain, and it's the one that kind of more emotional and a bit more reacting to things that touches us on the feelings level. And that is exactly how you touch this part of the brain, is talking about the why, not talking about what exactly you're selling, but why it is important. That's also why I just spent another couple of minutes explaining you why I'm talking about the why. But let's dive a bit deeper into this. I really like the phrase that privacy is a team sport. You really cannot do it alone. And even if you have a team of, let's say, 20 privacy professionals, the best of the world, you still will not be able to mitigate all of the risks that have to do with privacy if all of the company, everybody who processes personal information, or one way or another has to do with privacy, private information processing, you still will not be able to mitigate them if they are not aware of why it is important, what you are doing, what should be done, and what privacy risks are there at all. I think we cannot really, you know, play it alone as privacy pros. There's always, you know, there's always a risk. I'm repeating myself, I'm sorry. There's always a risk that you won't be able to foresee if you are not doing it yourself, if that makes sense. And that translates into a very simple, but yet I think not recognized enough phenomena of the idea that privacy violations can be both intentional and not intentional. And many people would say, wait a second, we don't want intentional violations. What do you mean? I mean, all of our job is actually against unintentional violations. I mean, we're not even talking about intentional ones. However, I think in the today's world of, you know, technology is so developing so fast, much faster than we're able to regulate it. We are at the risk of developing this mindset where it is much more important to move fast and break things at any cost. And privacy is very often this exact cost. And we see that as examples of huge corporations and how they don't really mean to violate our privacy, and they are probably not, you know, evil giants sitting in front of the computer and thinking how to violate privacy, but they just do it because this is their process. This is how they do things. You know, this works for them. Say monetizing data is their business model. They don't want to violate anyone's privacy, but just because they don't think in the categories of privacy risks, it can be recognized as intentional privacy violation. With unintentional, I think it's more clear, and it's simply a human error. I think the previous Ibrahim just held the whole talk about how this can be, you know, translated into security incidents, data breaches, and on different scale even. So I think both of those, the intentional and unintentional privacy violations, are risks if we are, you know, processing personal data, and if we are especially bigger organizations. And both of those categories of violations should be worked with. And I think that there is two ways to approach this. We of course can be what I you know, kind of not seriously call GDPR police. I live in Berlin, so I am very much identifying with European context. But GDPR being one of the most aggressive legislations in data protection field today, We can, of course, threaten people with fines and say that there is compliance obligation. We have to do it. So please go finish that training course, learn it by heart, and do the test tomorrow, which actually works, I think. And for many people, it might work, but I don't think it will work for everyone, especially for people who work in the fields that are very far away from privacy, who will be very demotivated to learn, and not even demotivated, but really just not interested. For them, it's something that is not in their KPIs, something that is not in their risk registers, so they wouldn't really bother spending time. Although they might click through the training and finish the training just because they were told to, but it doesn't mean that they will implement this into their work or remember these things or kind of internalize them. And that's why I think there is a much more, let's say, sophisticated approach to awareness, which is to raise excitement. And I know it sounds like something very, generic, like how do you raise excitement? I mean, it's how do you work with that? That's why I think I prefer to think about it as something that is a very long-term thing. So you kind of spend more time on telling people about values that privacy brings. And it actually brings value not only to the users, to the data subjects or whoever is on the other end and whom data actually belongs to, but also to the company, because, users stay longer, users come for privacy, and so on. So what I think can be done in order to raise awareness, and this is something that, again, I don't expect you to wow at these ideas. I'm just trying to, summarize things that are probably obvious in this or that way, but it's just not talked about enough. So we can see the main purposes as, compliance awareness. Of course, it is important that people know our processes because of compliance obligations. It is important that they understand what the legal risks are behind those processes or not following those processes. And also they know that they have to proactively include privacy teams. So they know that there is somebody who takes care of privacy if there is a critical situation, and they know how to approach them and so on. There is also another thing that is, again, a much larger goal, a much more long-term goal, which is to develop this privacy mindset. And I think it's a much harder thing to achieve, but I think it pays off much better, because it means that people are going to think about privacy proactively in advance. So they you want them to ask themselves before they start the process or while they are starting something new. They think about privacy almost automatically, because let's face it, at the moment, people only come to privacy professionals after they already built something and they realize that they need, GDPR compliance. And they're like, oh, but maybe we shouldn't launch before we have a privacy policy. If you have privacy mindset, however, then things are turning the other way around, and you have the ability and time and space to think of privacy violations before something is already, set in stone and built. Christina switched on the video. Is probably going to tell me that I'm running out of time.
No, as I told you previously, you have a lot of time, but in case if you ended with your presentation, we can continue with the questions. So let me know when your presentation will end, and I think you can take 5 minutes, for example, and after this we will perform with these questions. Thank you.
Yeah, sounds great. Sounds great. So
we can't hear you. Maybe you turn off your
Fortunately, or
yes. Yes.
I didn't change anything.
Could you please repeat? There was some troubles with the sound. Okay, thank you.
Okay, can you hear me now? Is it
yes,
fine
now
now?
It's okay.
Okay.
Yes.
Okay, thanks. So yeah, I'm coming to the final part of my presentation where I'm going to talk about how to achieve this, awareness goals. And actually, I don't think that it's necessarily bad that we don't have a playbook to follow. It can be we can be actually, you know, take it as a fun challenge and see what works and what doesn't. So to my mind, those two goals, the compliance awareness and the excitement and the privacy mindset, they translate into those two things. One is the training, which is, you know, a bit of a formal part, is when you actually make employees learn something and test their knowledge. And this is obviously up to company culture to determine how exactly you're going to do that. But I think this is an important part where you actually give information. This can come in any form and shape, and should be, to my opinion, followed by something less formal, by awareness activities, as I call it, something that, you know, kind of lowers the pressure around this whole privacy topic, and where we have the opportunity to actually honestly talk about our pain points, which employees have a lot, I'm sure, where we have the time to, you know, celebrate how great it is that we have privacy and that we have those laws that, you know, give us so many amazing rights and opportunities. And again, it's also for your company culture to determine how exactly you wanted to do it, the form and the shape of it. How it may look on your roadmap is also something that is a very kind of, you know, it's something how I would see it. I think that we should start with basic mandatory training for everyone, but also followed by training for different teams, depending on how you assess the risks for different teams. There are teams that face out in a way where, you know, the data actually leaves the organization, and kind of, it's very easy from the outside to see what is going on with the data. Those teams would be probably customer support or recruiters are examples of those teams. But then those supporting awareness activities, I think they should not be kind of in a very strict way, planned in a very strict way. I think it's something that should just come naturally all the time and gradually, regularly come all the time. I think that was my last slide. I'm going to take the last minute to thank Christina and the whole team of organizers behind the Congress. I know it was a very short presentation, but again, my goal was rather to kind of keep the discussion about the importance of awareness going, rather than, you know, deliver something more deep and detailed. So do we have any questions?
Yes, yes, we have, Maria. Thank you very much. Your presentation maybe was short, but really very useful with a lot of new ideas, I think, for privacy experts. And I also want to call my colleague, Oleg Blinov, to participate in a Q&A session with Maria.
Hi, Oleg.
Yes.
Sure. Hi, Maria.
And after this, I will transfer my word to Oleg on the whole DPO session. So, Maria, you just told us that privacy training and privacy awareness program should not be something formal. And in case, for example, in most of international companies, after privacy training, which may be created via some cinema or with some animation, there can be some testing. And what are you thinking about the testing of employees? Because as from my side, testing has some pressure while you're doing it. What do you think? Is it useful, or in your organization, for example, you do not use testing, you just complete your own awareness program?
I think, as much as I think that around awareness activities, there should probably be less pressure and it should not be as formal. I also think that the training part would actually could use some formalities, and that being first our compliance obligation to prove that we actually trained the employees. So that is already something formal, right? We need to kind of store the information about who did training when and how well. Well, probably not how well, but that we trained them at all. But also about tests, I think that is a very interesting metric to not so much to judge how much people know privacy, but actually to know, are we doing it well enough to train them or not? So in that regard, I think testing is important. The other side of it, though, is that not many people love learning about privacy, and they will probably love it even less if there will be some very hard test with, very with a lot of pressure of passing it, and so there should be definitely a balance in terms of how you frame your questions, how is it a multiple choice, or do you make them write an essay and then there's only one attempt to, so I think there should be some nuance to how you test, but you should test, I think.
Yes, thank you for your response. And also, I just want to highlight that when we, for example, working in privacy sphere, we only concentrated in privacy aspects. But for another business units, for example, for accounting or financial, privacy is not so important as we see.
Absolutely.
And when the employee completes the training, very hard terms and legislation matters maybe not so necessary for them. Oleg, do you have some questions to Maria? I think yes, because
there's one topic that I'm really fascinated speaking with people about is how you make the case for top management that privacy is a beneficial matter. And there are many arguments for that. And the question for me is probably how to structure these arguments, because you can say like, we will lose that much money and that and that. And it's really hard to make it into a solid story of what you want to tell the management, because you don't want to scare them too much. It doesn't really make sense to say, well, 20 million euros, because they don't trust you when you say like these high numbers. It must be much more realistic like level of risk assessment. And I find it often complicated to have in just one like solid paragraph to have a description of everything that can go wrong and what will become better if we implement privacy. So what is your strategy, Maria?
I think that's a very often the problem that we privacy pros face. And on the one hand, it really depends on on the people in the company culture and top management values. There are companies who are very openly stating that they are, don't care about privacy and really just want the compliance. But there are companies who are a bit more ethical in that sense and want to be, a bit more sustainable in the long term. And there is, of course, nuance between the two extremes. My approach is that I think as much as I want to believe that, people are good and they want good for the users and so on, I think it's very good to also bring some very exact metrics to the table, because we exist in a corporate environment. And those metrics can be, depending on your resources and time, it can be something that you get from your users. You essentially try and see what works with the users, and do they stay if you make your product a little bit more privacy friendly. Start with something small that is easily adjustable, and then show that, we got more users using that more privacy friendly feature than the less privacy, this kind of things. Or you can just do the qualitative approach and research through just asking them questions and ask your users, do you care about privacy or not? And see what happens. And these things, I think, work or have a potential to work with top management a bit more than just explaining them the theory of how privacy is a good part of the brain in the long term and things like that.
Ibrahim, as I know, you want also to add something, because you are from training company and have a lot of knowledge about how to train. Just take your word. Yes, thank you.
Thank you very much, Christina. Yes, and I agree entirely with Maria, what Maria has just said. I'd just like to add that I think it's important that to the board and senior management, we talk about privacy in terms of customer value as well and customer trust, that if we lose the trust of the customer in terms of how we are processing their information, if they see their information being lost, stolen, not being respected, they will lose respect for the brand, they'll lose respect for the organization. And eventually, as Maria said, in the end, where commercial organizations, customers will vote with their feet out of the door and to rivals which see privacy as a more important issue. So I think that's where, in the end, board members won't just be convinced, because as we all know, privacy is a human right after all. It's worldwide. Every country is now bringing privacy legislation. That's important. But as important to board members is the fact that the trust in the organization is going to weaken, but also the brand itself, which means it will have an impact on the bottom line as well. And people are, as I showed in my presentation as well, are becoming much more aware of their privacy rights.
Right. Yes, I totally agree. I still face some challenges with companies that I work with, for example, with respect to retention schedules, because it doesn't really show on the outside. It's some dumpster out there. Okay, we put some password and some control measures on it, but no one will see that we, for example, didn't delete some sort of information that's lying as a log down there. And that's another, like, a balance to strike and to convince management that we have to be true to ourselves and to be truthful to our customers, and not just to proclaim on the outside compliance, but do it on the inside as well.
Yeah.
Okay. Yeah. Christina, I think we can start the DPO session if we have everyone.
Yes, colleagues. I just want to thank you, Ibrahim and Maria, for your knowledge and for your sharing experience. Yes, and we have 2 minutes just to synchronize our our Congress in live and Congress which will be broadcasting via YouTube. And maybe in future we can organize a session regarding awareness aspects, because as I think awareness is the main point in privacy processes and privacy building, because without people, without employees who do not know what to do regarding privacy issues, or company processes will not work in. So thank you very much, Ibrahim and Maria. And if you want, you can stay with us. We will be conducting DPO session. And I also want to invite everyone from our speakers to section results, which will be after DPO session. So Oleg, I give my word to you, and these 90 minutes are yours.
Mine and the one of our great panel, because we honestly have a great panel of participants of the DPO session, and I would like to introduce each of you. So we have Ekaterina Kalugina from Double Data, we have Diana from Moldcell, we have Petros from Wargaming, we have Darryl from Miro, we have Punit from Fit for Privacy, and finally we have Igor from PlayerX. So welcome all. I'm looking really forward to this discussion. I know we had this small conversation, like organizing event before the panel, and it really fascinated me the number of industries that we represent, the rich background and experience that we have gathered. And probably it will be most helpful to provide a bit of coloring of our own experience if we could introduce the challenges that come with your industry practice or with your organization structure in which you live in. So probably, Ekaterina, if you could start, I think that would be a good start to then move to a broad discussion.
Hello, Oleg. Hello, all the participants and speakers. My name is Ekaterina Kalugina. I'm Chief Legal Officer and Data Privacy Officer in Double Data. And I work as a lawyer more than 10 years, and work as Data Protection Officer more than 4 years now. It's a little bit challenging to combine the functions of Data Privacy Officer and Chief Legal Officer, but in Russia it's not a unique situation. very common. It's very common. And I currently work for a company, a Russian Cyprus company, Double Data. Maybe you know this company. It's famous for due to our long-term dispute with social network Vkontakte on the possibility scraping and indexing open data from social network. And also this company produces search technology and anonymization techniques for searching. And what I can say, I'm happy to be here, first of all, and I'm also a privacy enthusiast. I believe in power of privacy, and I'm a member of RPPA, Russian Privacy Association, Professional Association, and IIPP. I hope that our session will be very useful for all the participants. So,
thank you, Katerina. I think that the financial sector in which Double Data works in is quite interesting. Well, it's an IT/finance sector, because I understand that the product that your company is offering is often used by banks. And this is a very interesting conundrum of having two risky activities. One of them is web scraping with respect to data, and it's I think it's a really interesting challenge to keep privacy at the same time while handling this amount of data. And given that it has far-reaching effects, especially connected with the financial matters, which we all typically find to be intricate, to be sensitive, I think that's a very challenging environment. And I'm honestly very, very interested in the discussion that we will have. I think we had also a discussion with Petros regarding different structures that can happen in the company, different setups of the position of the privacy professionals. So if you could introduce us to this perspective.
Yes, thank you, Oleg. So the thing is that it always comes down to the question, what are the specific needs of the organization? First of all, one needs to look at the business structure, the operations and activities of the organizations, and how it wants to comply with those business, generally the operations that they are processing, for example, personal information across the globe, or whether they should take it more on a local level. I would talk about from the gaming perspective, from the gaming industry perspective, which the things are a bit more complicated. It's not that easy to understand how gaming industries are generally structured across the globe. They operate globally, first of all, because there are the games and everything that are distributed via digital platforms are accessible on a global level, and therefore the obligations, the operations and activities are very large, and a lot of things need to be taken into account. The thing is whether you need to appoint, for example, an in-house DPO or an external DPO. It comes down to the question of how actively you want the DPO to be engaged into the decision-making of the organization. Of course, talking from the GDPR perspective, there are some requirements of the tasks of the data protection officer. And I will say, for example, Article 38, which says that the DPO should be involved properly and in a timely manner. So whether someone, an external DPO, can be engaged in such activities within the organization, then it's a food for thought. So it should be holistically view and assess what is needed best, and then to decide what will be the best to adopt in the organization.
All right. If I recall correctly, in 2019, a DPO of our sister company in Luxembourg, she participated in an event with the local data protection authority, and they provided her with a list of 11 requirements to DPO, and one of them was that the DPO should not be constrained by resources. which is quite funny, but the question still stands. How do you prove to management your value while being an impartial DPO, where you are essentially like a little data protection authority within the organization, and you're basically creating like additional pressure while being paid by the company? So I think that's a challenge. How do you cope it within your company?
I think the key here is the privacy awareness in education. It comes down to educating people, and also the message should come from the high senior executive people. Definitely, there are a lot of things to be done within organizations generally to get the message out to the employees and on how to respect the information that they have in their possession, how they should treat it and handle it, and generally to raise at least the risks and concerns that such operations, organization operations, entail to the business. It comes down to the data governance, again, a framework on how you
I think Petra's connection is lagging.
Yes.
Yes. Yeah. Does anyone else want to jump in on the topic of building like connection with your management and showing the value that you bring to business and making people want to help you, like finding your sponsor in management? Yes, Punit?
So I think building relationship with management doesn't happen overnight, but what you got to start with is, as we were saying in one of the earlier presentations, you work with somebody who trusts and who wants to work on data protection. So that's the prerequisite. And if that prerequisite is fulfilled, you start developing a culture of privacy. You start developing a company in which privacy is respected and data is treated with respect. That's the premise with you start with. Now, how do you do it? We talked about awareness, we talk about creating culture and running a compliance program, and then bringing a holistic project which integrates with security, compliance, risk, and even other regulations that are being implemented. So there's no secret, but start at the top and start getting in elements bit by bit. And as you cascade things through a structured approach, through a roadmap, through a plan, which is usually 2 to 3 years roadmap, you will establish trust. But if you're trying to say, hey, I'll get you compliant in 3 months, well, it may create trust initially, but in the long term, the trust will erode. While if you do other way around, 3 years, there may be some challenges, but eventually if you hit the right person and make the right connections, you will have a long-term relationship and the company will benefit.
I also am hearing sometimes a lot of nihilism, either from the C-level or like from individual developers regarding privacy matters. Some say, for example, as an argument that often comes up is that GDPR and other like regulation heavy regimes are built to benefit big corporations, which have the money and the resources and the lawyers to protect themselves, and if they fail, they go to court for 2 or 3 years until the matter is resolved. The money will get back to basically the money that they will spend on litigation or on the fines. And many like small companies and medium companies do not take these regulations seriously because they believe them to be a stopper for development of business and for basically competition. What do you think about this this argument and about this this theory that indeed it benefits large corporations like Google, Facebook, and others?
Well, it depends who you talk to, because I think if you're driving on the road and we say the red lights and the cameras are only for the Porsche and the Ferrari and those cars, and rest of us can just drive what we want to do, don't have to follow the rules. Well, that's an argument to say, but that seems like a lot of frustration with the system and approach. While the rules are there for everybody, and if we follow it, it's not just because there's a law, it's because it makes the data use and data leverage much more safer for everybody. If you look at it from that perspective, and also that it's the human rights or human values which we are protecting. I mean, every one of us can say we don't need protection, we don't need privacy. I know there are some people, but then you got to ask them, and I asked them at many conferences, maybe I can ask this here also. If anyone believes that they don't need privacy, just send me your name, bank account number, username and password for your bank account. My email is punit@fitforprivacy.com. I have never ever received, maybe 10,000 people would have listened to that, but not yet sent it. So that means privacy is important. So the argument to say it's only for big companies or small companies doesn't hold true. It holds for every one of us.
Right. And I also find it hard to preach privacy consistently when there are like large data leaks and people say, okay, like transparency is a good, but look at all the data that's on the black market. Why are we trying to solve these like smaller issues, which are small from the outside, from a non-professional view, but we have like experience and we have this insight from regulators that transparency is indeed a focal point for compliance. Now, it is hard to convince like everyday people in layman terms why the privacy is important in addition to information security. And information security often takes the foremost role in convincing management that it would make sense. So do you experience some sort of like competition with information security, or do you see this as areas that can help each other?
I would say both work in harmony. There's no privacy without security. So you can't say security and privacy are competing. Privacy is about ensuring and assuring people that we are using their data in the right way. While we do that, we also need to make sure the data remains protected, and to make sure that it's protected, we need information security. So it's an argument that I can't buy in. Rather, I would say they are complementary. It's like, I need a coin, but I want only head or tails. You will have both heads and tails when you have a coin.
Yeah, the question is rather when you have like a meeting with the C-level and they say, okay, we have, for example, 4 or 5 people that are ready to work on the topics of information security and privacy. So which projects should we put into priority? And in many cases that I've witnessed, it happens that information security takes like the foremost importance. And then if there are any resources left, then privacy is taken into account. Does anyone else experience this in their work, or have you structured your work differently? Anyone?
Yeah, just have a lot to comment on previous issues.
Yeah,
so,
go ahead.
First of all, when smaller companies claim that they don't have to care about privacy, that's a little weird, because okay, they're not on the radar because the big ones are. But if you want to scale your business at some point, you'll have to take care of these issues. So there's like no other way around, and there is user expectations of larger companies to take this into account. Secondly, I guess I can also say that privacy professionals, they don't work closely with information security only, but you work with all of your product teams. You work with marketing, you work with, I don't know, business development, with product teams. So this is kind of complex work you have with everybody, and everybody should be involved. And this is what the regulators are expecting from you, that you're not like a single warrior, privacy warrior within the company, or okay, you and one guy from information security, but you actually have a team implementing privacy by design and privacy by default principles and so on. So that's my take on the previous issues raised. Just a brief one.
Yeah, thank you so much, Igor. And I think that the question of convincing is also very much dependent on how much you're integrated into the structure of the company. And I think we discussed with Petros the differences between in-house and outsourced DPOs. So Petros, if you could join us and tell us your take on this issue.
Yeah, so I think the issue comes to the fact that how the company takes privacy seriously. As my previous colleagues have mentioned, it comes down to the culture, comes down to the values, comes down to everything, to the structure of the company, to the size of the company, to take into account how they operate, at what scale, at what level, and so on. There are definitely pros and cons in terms of appointing an in-house or an external DPO. As I have mentioned at the beginning, we have the GDPR, for example, that specifically address the tasks of the data protection officer, have certain requirements which needs to be taken into consideration. For example, the DPO, whether it's in-house or appointed as an outsource, needs to be involved in all processing activities, in all issues that relates to the processing of personal data. Now, whether this is something that is manageable in terms for organizations may see this outsourcing as an alternative solution. However, one they need to take into consideration, definitely, for example, the big enterprises which they constantly dealing with, they have huge amount of processing activities. They need to consider whether they need someone to appoint in-house in order to be easily reachable, anytime available, to address any concerns, to attend meetings with different stakeholders, and to take into account the sensitive information of the company, and also to be ready in case that personal data breach happens, then to be immediately available and be there to address any possible, to take any mitigation measures. From the contrary, the external DPOs, they have the privilege of being they have more, it's more networking, I would say, more expertise on a specific matter, as they are more engaged with legal issues. They are well aware of any upcoming laws and how they might apply in practice as DPOs, in-house DPOs. They're too busy. They have a lot of things to take into account, not just from internally and also from externally, from customers, from employees. They have a lot of tasks to take into consideration. So they need to balance what is best for them and then to take the appropriate decision. Sorry, Oleg.
Sorry, yes, I muted myself. Yeah, I think a lot of participation of a data protection officer and basically any privacy professionals as an in-house professional is very much building in this privacy by design culture. And I think that's a very wide and interesting topic. And I think Yegor touched on that. Yegor, could you please tell us a bit more, like how do you come about the problem of privacy by design? How do you typically structure your participation in designing new products, developing of old products, etc.?
This is a good question. I think the key initially is to build trust with everybody on board. So you would get involved at the right moment and not by the time they already designed everything and decided to check in with the privacy team, like, are we doing the right thing? So this is the key. I think it's also very difficult for existing companies which already built something. And this is very difficult to rebuild something that is already working. I think this is one of the challenges of day-to-day privacy management, where you have a lot of processes initially designed in a different way, and there is no easy way out. So I don't have any practical solution for that yet. Again, initially, it's building this network of privacy champions within the company who understand that new features and new products, they have to be rebuilt. But in terms of existing products, you just wait for the right moment, I guess, and you take all the imperfections you might have initially. So I think it's a very, very tailored thing for everybody, and it's much easier if you could get involved in the very early stage of the project. Then you can help everybody to build privacy compliant solutions. Maybe in the future we would see some, and I know some startups working in this area where they are developing their third-party solutions, which they would sell to companies in the future. But we are very far from it, I guess.
Right. I also noticed that there may potentially be a certain conflict between current development methods and privacy by design, even though one of the principles of privacy by design is that they are mutually enriching. I noticed that the logic by which many product managers operate is that let's build a test prototype, see if it works, see how it solves our solutions, and only then invest time into building a proper solution. And typically this comes into conflict with privacy by design because you initially want certain safeguards to be implemented, while product manager will tell you, we don't know whether this will be the final variant and whether this will be like changed 180 degrees to totally another solution. So do you guys see the same problem? How do you see the solution to this agile methods of development?
Oleg, in my opinion, sometimes there are different interests between development, not development team, but marketing team. When we say about, for example, dating application, marketing specialists would like to collect as many data as possible. And it is not, it's not about privacy, it's about the interest of receiving many income in the future. And of course, in the ideal world, development teams need to get advice of privacy specialists on the stage of minimum valuable product. But in the reality, they don't think about that in the stage of MVP. But then on the other stage of development, it may be too late to think about privacy because right. They used because they used algorithms and algorithms which conflict with privacy issues, with data protection on the core. So,
yes, I think Igor has something to say.
Yeah, I don't think that the key problem is in the product design cycle or something like that. I guess the problem is in the purposes, and certain business models heavily relying on data harvesting and processing as much data as possible. So as long as these business models are not discouraged, as long as the alternatives are not promoted, the teams are just optimizing for the best.
Exactly.
And unless there is certain alternative which is selling, like, I don't know, the recent example can be Apple, although they're heavily criticized from many areas. But if privacy starts selling, that this is something which might be considered, I guess, at some point. But you have to have a lot of examples, and currently this is just Apple.
Yeah, well, with Apple, it's really quite interesting because I think I saw their recent chart regarding advertisement. And as you are probably aware, in the latest iOS version, they made access to IDFA subject to consent. And this made targeting by Facebook and other advertising partners very difficult. At the same time, Apple is offering their own advertising optimization network called Scott Network, and its growth is off the roof. And basically because they are exclusive on that. And Apple, while I initially took Apple as like a privacy champion and advocate, I now have doubts regarding the motives, really. And what about you? Well, I think that it's a very rich field, and at the same time, I noticed that privacy is sometimes being hijacked in order to strengthen one's monopoly. For example, some technologies that are very, very advanced are only available to like big companies. For example, only Facebook can have the money to, or Google or other big companies like big tech has the money to make their own labs to research these advanced technologies and produce them in-house. And it often excludes additional players from the market. So I think it's important to take into account that privacy can be hijacked, and maybe we are in a situation where it leads to further consolidation of, for example, the advertisement market. And again, this jumps back to the question of whether maybe GDPR is very much beneficial to big companies and how we should be living in this environment. Do you think that it would make sense to make like certain tiers of compliance for different size of companies, because it already is implemented in certain other regulations in the EU, including because for example, I think the Digital Services Act and Digital Markets Act have a certain distinction for like typical players and big tech. So maybe it would make sense to differentiate between them and place higher duties on big tech. What do you think about this idea?
I'd like to jump in on initial question of Apple market power and use of the data. There was a very nice article called Apple Robbed the Mobs Bank, actually cutting third parties and especially Facebook from part of the advertising revenue and locking the data within Apple ecosystem. Yeah, and I agree that there might be some tiered approach to privacy compliance burden and expectations, something similar to what the OECD is doing in tax, where there are certain obligations for companies with substantial revenue, like over 750 million euros and so on. So something similar can be applied to the number of consumers, something like this. So this is definitely important because the companies are not positioned the same way, even just to negotiate simple data processing terms with each other. And we face it all the time. Like you cannot just say like no, or like let's negotiate when you're working with big players. And this is a big problem. So yeah, I guess differential approach in terms of privacy burden is important. And also what is interesting looking at Apple's case is they are also heavily criticized for, okay, they pioneered this privacy champion vision for their company, but then certain things that they try to implement, reporting the images with child abuse and something like this, with the system CIPM, this has been heavily criticized by Electronic Frontier Foundations and privacy advocates worldwide. And this is a very high bar the company can take. So if you really want to go this way, this is very difficult to observe, because one part of your business might be very happy with promotion of privacy values and so on, but you might have internal conflicts like developing your advertising business, bending to the pressure of the regulators worldwide, pushing you into providing backdoors to your software, monitoring certain content and so on, or localizing your data, because Apple is localizing data in China. So there is a lot of tough choices. So, on the one hand, Apple can do a lot of things. On the other hand, they face so many challenges. So I don't know whether smaller companies really want to be in that position.
Right. I think you touched upon a very interesting topic of vendor management and how we can or cannot negotiate certain contracts. I have a small anecdote. A couple of months ago, we started using, well, we looked at starting to use a certain service. I said, okay, we needed data processing assignment with them. I looked at the terms of service and they say, okay, so you have to download this PDF, sign it from your side, send this to this email address, and we will revert to you with the signed, countersigned copy. So I did this. They didn't respond to us for 1.5 weeks. I asked the manager to contact their sales manager, and the sales manager said, oh, we only sign DPAs for premium plans. And that was like, what? Really? Is that a premium feature, like protection of data that we provide to you? That's totally nuts. And I see this more and more often, that it's really hard to negotiate like contracts that are just published on the website and say like, take it or leave it. So how do you structure your vendor management in terms of which standards you try to apply to your vendors, and how, well, probably most importantly, you communicate why these requirements are in place for your team, because your team just wants to use this new shiny tool that's on the market and it's really cool. It has got a great UI. Well, the legal stuff is shit, but well, come on. Well, we're just going to try it. And this is where the conflict arises. How do you typically manage it within your organizations?
Hello?
Yeah. Oh, Jana, we can hear you.
Yes,
yeah.
Yes. I could include here because I'm dealing very often with all of these kind of data processing agreements. In fact, with all our partners that are dealing with personal data, but in fact, I'm working in a telecom company, so approximately 90% of the partners are dealing with data processing agreement. So it's a kind of negotiation of this role type that we stipulating in that agreement, like controller, processor, because it's a very complex area, very dilemmatic often, because in telecom, not only telecom, in tech companies, there are a lot of complex operations that there are different phases with different role types. There are sometimes situations when there are multiple role types, even with the joint controllers and so on. So it's very interesting, sometimes very hard to negotiate, especially when there are different jurisdictions. So it's interesting, but in the same time, all our projects, we haven't touched the topic about data processing impact assessment in regard with the privacy by design. So all the projects usually are going through this data impact assessment. So we are analyzing what are the purpose, the initial purpose, and after that, what we will deal with this data, what are our plans, what are the risks, and based on this, we can decide to go further or not. So this is a very important.
Sorry, Diana, I don't think I can hear you. Yeah.
Hello, hello.
Yes.
It's a very important tool to analyze in order to go further with the project. So if you have some another ideas how to develop this risk assessment, because you have touched the awareness, the awareness subject is very important in a company when you are dealing with the risks, because for example, when you talked about small companies, in some cases, small companies, maybe the financial impact is not so much as reputational name. I mean, when you lost or yes, you lose the customer trust, because there are sometimes years in order to gain this trust, in order to gain this customer database, and just in one time you can lose it. So it's not always about just the money.
Right.
Yeah, I wanted to add a little bit. In Europe, we also have the European Banking Association guidelines on outsourcing. So these are a good tool and a framework which allow you to decide on how you want to set up your team, how you want to set up your vendor management, how do you want to outsource, and what due diligence or post-contract activities you need to perform on vendors. So it's a very comprehensive framework. And if you apply that, that can be a good start when you're asking how do we manage the third-party relations or third-party data transfers. And if you combine that with GDPR, then you have a very good solution.
Cool, thank you. Igor?
Yeah, I'd like to add that answer to your question depends a lot on the structure and whether you operate globally or you have some key markets where you have to observe just local requirements. So if you have a number of operating companies for the regions, for example, for Asia, for Americas and Europe, that might be easier because you have, at the moment, more lax requirements for the regions outside of the EEA. So that might be easier for you, and you will not be forced under the law to enter into data processing agreement with your partners. However, if you have just European-based operating entity, you have no choice, even when you're working with the audiences in China, the US, and so on. So you will have to take a balanced approach and sometimes meet the demands of the teams, and also assess, is this a kind of long-term relations, or this is just a test, and so on. So there are a number of solutions you can take. But again, it depends on how you operate, what types of data you're working with, how sensitive they are. So very, very tricky just to provide any kind of meaningful framework for everybody to rely upon.
Right. By the way, while we're speaking about international transfers, I think it's been 1 month since the new SECs have come into force. Has anyone concluded their first new SEC?
We're on our way, but the trick is...
But none of them finished.
The trick is usually your partners consider this as a good pretext to renegotiate certain terms you entered into before. So this is not just easy thing like we need to replace all the SECs with the new ones. They say, yeah, that's great, but we also like to draw attention to this and this clause. So that's a trick.
Yeah, I also notice it's quite hard without a predefined network framework to assess the security measures that are in Annex 2, because there are 18 of them. And how do you react to them saying, hey, we're a processor, we're not supposed to do data minimization, we get the data that you provide us, like what do you want from us? And I don't really have a response to these situations. Do you? Punit, I think it would be valuable if you could provide us a small walkthrough through the vendor risk management framework of the European banks that you mentioned. Maybe the answer is there.
I would say at the very highest level, it's in 3 steps. The first and foremost is you got to do due diligence for vendors. That means you need to know your suppliers, you need to check. And that's not just privacy perspective, also if they're financially viable, if they're not having any criminal activities. I know I'm using a strong word, and basically do a due diligence, carry out checks. And the large banks and everybody, they go in with hiring or some buying services which tell you how good or what's the profile of the vendor. So if most of the reputed vendors are in there, first and foremost is due diligence. That's the highest level of due diligence. But within that, you got to do your own due diligence, check for GDPR compliance, check if they have certifications or any other privacy compliance. So that's the first step. The second stage is the contracts that we all know, where the data is going to be, who will have access. So do you need standard contractual clauses? Do you need additional measures? And the notion, what we call usually is DPIA, the Data Protection Impact Assessment, that translates into something called TRA, the Transfer Risk Assessment. You perform a transfer risk assessment, evaluate purely from transfer perspective, and then conclude a contract while mitigating the risks from the transfer risk assessment. That's the step 2. And then step 3 is around, you have the contract, everything seems fine, but how do you make sure that it is actually fine? So one is keeping an eye on your news and keeping an eye that maybe a data breach has happened with the vendor and you're going to maybe look out if you are impacted. That's the easiest way. But then it also gets into the stronger ways like conducting an audit or asking them to fill a questionnaire or using a tool which will capture on a regular basis how are they doing. And I think that's an open market wherein eventually we will see companies coming up with a registration of all the vendors and saying this is how they are performing on privacy compliance, and you just got to register and use it, rather than from a vendor perspective having to fill for 500 customers of your 500 assessments in 500 different ways, asking the same old questions in the same way, in different ways, I would say. So that's the 3 broad steps: perform your due diligence, do your contractual bits after assessment, of course, and then keep on checking if the risks are being mitigated. And yes, when you close the contracts, make sure the data has been removed or deleted or treated effectively. So that's in essence at a very broad level. And it also talks about conducting the sourcing requests, so RFIs, RFPs, and RFQs, not just going out with one vendor and having some standards, and that leads to the accountability principle which we have in GDPR. So that's why I say it's a holistic framework from all dimensions.
And how do you combine the different approaches in different countries? I think we spoke about like the position of the global DPO at our preparation call. And I think that it would be a nice point to transfer to this topic, because indeed transfers are probably the scenario where different jurisdictions come into play, and your compliance with different jurisdictions has to be structured. So what is your take on this?
And I think Igor already mentioned, even in the transfers, you need to look at what's your scale of operation or regions of operation. So when you're looking at saying global, you got to understand what's your landscape, what are the regions in which you are going to comply. So is it a US-based company providing services in Europe and some other regions, or is it a European company providing services anywhere? But cutting the long story short, the simple thing is you cannot have a law by law approach. That is, you can't say I'll go to this region, then have one approach, another, because that will complicate the processes and systems you will have behind it, and people will not know what to do. So the best way is take one standard. I would say normally the strictest standard. That is, if you are an EU-based company, you take GDPR, and if you are in any other region and you believe that's stricter than GDPR, then take that as a basis and convert it into what we call a global privacy policy. And I'm not talking about the policy on your website, because some US companies think policy is on the website, while for us in Europe, it's the notice or the statement on the website. So I'm talking the internal data protection policy, which guides your staff, employees, management on what is to be done. Because you don't want every staff member to go, or every region to go out and start looking out, this law we are going to implement this way. You say, this is how we want to incorporate privacy principles into our business. These are the requirements, and give them a head start and tell them we have incorporated the GDPR, the CCPA, the PDPB, the whatever, all the names or acronyms I can use, and we have factored them in. If there is anything, we will as a global team take care of it. So put that policy in first. Then you explain that approach, why it fits. Then of course you'll have debates with every region. So Singapore defending that their law is a little bit different. US coming in saying we are a little bit different, even though some of us believe they don't have a law. I mean, the federal privacy law, I mean. Then we will have the Indian colleagues saying, no, we don't have a privacy law, but we have this. And Taiwan and Korea and everybody. And that then becomes a challenge, because you got to defend your policy. And the only way to defend that policy is to say, okay, let's do a rational fact-based thing, saying how is your law different and which line items is it different. And then you're narrowing down the discussion and of course complicating it, and it can take sometimes, like I was working in a bank and we were operating in 50 plus countries, and it took us almost 6 to 9 months to negotiate with each lawyer, because one of the good things is our lawyers friends are capable of defending themselves, at least with the non-law colleagues or corporate colleagues. So the life becomes a little bit fun, defending and justifying. But once you have that policy, you have a solid foundation and basis for having, I call, a common unified global approach. And global is respectful of your regions that can serve for a long term. And again, it won't be foolproof, that is 100%, but it'll take care of 80 to 90% of your common use cases, common scenarios. And then when the Taiwanese law or the Singapore law are slightly different, you adapt the consent requirements, you adapt the privacy requirements where, as and when needed. So that's my usual philosophy. Go, analyze what's the landscape, build a policy, and before a policy, build a strategy, because you got to get an agreement in terms of business rationale that it'll save cost, it'll make it easier, it'll be simple systems, simple processes with some exceptions. If you get that strategy agreed, then build a policy, and then it's about implementation. And don't think if that was difficult, that the other part is going to be easier. That's going to be even more challenging, because we think we'll set the policy, but the systems are already diverse, systems are already region-based and so on. So then the real fun starts.
Right, thank you so much. Katya?
I would add that when we talk about global data compliance, we can use some approaches. And when we talk about data process, of course, we can use the approach one size fits all. But when we talk about the documents, privacy documents, data protection documents, sometimes it may be challenging to use a global approach, including developing global privacy policy, the languages, different laws in different jurisdictions, and there are two approaches I would like to highlight. First is minimal compliance, data compliance, when we comply with the crucial privacy and data protection requirements locally, and depending on the high risk. And we also know about other requirements and manage them. And another approach is maximal compliance, when we comply with all special requirements of data compliance in locally, and provide this compliance with all the requirements. So the approach, in my opinion, the approach depends on our resources, the company size, and the business. Also, I would say a little bit about local data protection authority, as I'm a DPO in Russia as well. There are many specifics in local legislation on data protection requirements. For instance, data localization, Foreign Companies Lending Act, and also Yarovoi law. That's why it's difficult, sometimes it's difficult to use a universal automated system due to different, for example, due to different deadlines for responses to users' requests and other differences in local data legislation. Also, in Russia, there is a lack of some clarifications on many privacy issues. I mean, we have on many issues like application of legitimate interest, balancing test, automated decision making, pseudonymization techniques, and local data protection officer needs to refer to European legislation, European opinions and guidelines to to apply some local legislation clauses. Another challenge is that there is a difference between many legislative terms, definitions, and concepts. I mean, the definition of controller, operator, processor, pseudonymization and anonymization, secondary use, and so on and so on. And also local DPO should take into account local languages and local legal requirements. For instance, when he or she drafts global policies, and it should be translated in Russian for Russian employees, for Russian stakeholders. Moreover, Russian Data Protection Authority, Roskomnadzor, has a very dynamic position on many issues, and it also should be taken into account because it's difficult to rely on these positions, and DPO needs to regularly check this position, and there are many risks connected with that. And also local data protection officer needs to monitor legislation both on a global level and local level. And for me personally, one of the main challenges that is the culture, is the difference between culture in Russia and in Europe on privacy and data protection. I need more time to explain local employees why privacy is important, and spend more time to provide awareness stakeholders and employees with data protection requirements. At the same time, for me, it may be not so difficult because I work for B2B company, and we work with businesses, and for our business, if we don't comply with data protection and privacy requirements, it's a stop factor for concluding agreements with us. So our income depends directly on data protection and privacy requirements.
Yeah, Yegor, you wanted to jump in?
Yeah, I'd like to add to what's previously been said. So first of all, again, it depends on the industry and whether you're a B2C or a B2B business. So if you have a consumer business, I think there are two approaches. So first is to apply the strictest standards to everybody. And I favor this approach, especially given a quite recent example when WhatsApp has been heavily criticized by users from India when they were objecting to a different state standard of treatment of their data compared to European users. And if you don't want to explain why you treat your users differently, this is a way to go. On the other hand, if you're not as big as WhatsApp or like other larger companies, you can get away with treating different users differently. But again, you might be caught at some point, and that would be a difficult thing to explain. So when we, for example, analyze how consent is implemented by different gaming companies, we noted that we have to try games from different accounts from Europe, from the US, because sometimes the experience would be different, and user experience would be different. So I favor a global approach where you choose the highest standards as long as it's operational, because your teams would be also happy to have just one standard for everybody, and it's easier to implement. And secondly, you don't need to think about like every market you operate on. You focus on key markets for your business in terms of revenue, and then you also with experience get some ideas of what regulators are the most active, where a lot of discussion is going on. For example, the UK has been generating a lot of work recently for everybody working globally. So you just keep an eye on certain countries, and that actually makes it easier for you. And one more note on the previous question on data minimization in contract management. I think the key is to figure out how you can operationalize the requirements. So when you can tell your vendor what you expect from them in terms of data minimization, not just the source, yeah, we get it, but some steps they have to take when working with your data. I think that might ease the process and the expectations.
I think just to highlight some of the critical success factors when we talk about globalization and standardization, because it's easy for us as consultants or as advisors or as DPOs to say, do this or do that, but it needs a firm executive buy-in, and the organizational strategy also has to be standardized, because if the organization strategy is each region is empowered, each CEO is empowered, each vice president is empowered, you can't have a global strategy for privacy in that case. So that's the first thing, the executive buy-in. The second thing is there would always be noise, even if you have executive buy-in. There would always be people saying, we are special. But what you got to look at is treat exceptions as exceptions and not exceptions as standards. So those who are making say, or defending their territory, look at them and agree with them how you can support them while having a common minimum standard. So your global approach does not have to be the 100% global and no flexibility at all, because that will be difficult unless you are only operating in Europe and thinking we are operating globally. So that's not going to happen. So you're got to be flexible somewhere. That is sometimes called like think global and act local. So give them that common minimum standard, which everybody can follow, and have them leverage around some points like consent is different in Taiwan, consent is slightly different. If you have a way in India, they confuse or they're saying consent as contract. So you got to fit into all those needs. And last but not the least, in those cases also leverage upon existing standards like the NIST or ISO 27701 as a basis, so that you are not saying these European headquarter people don't understand my country, they are only imposing the GDPR. So if you use that, then you neutralize some of the discussion. So those are some critical success factors based on experience that I've seen. And if you don't have them like the executive buy-in, then don't even think of standardization, just flow with the flow. Though I know it's counterintuitive.
I think that the topic of standardization is indeed important for our industry. And Darryl, if you could take the floor regarding Miro's certification with ISO standards. I think Miro is certified 27001. So do you see it as a connecting factor for compliance with regulations across jurisdictions?
Absolutely, and I completely aligned with Punit, to be honest. I do see it as a very good way of aligning different regimes and building in some base controls to allow businesses to scale, right? I mean, we'd love one data privacy global law, but I guess we're a long way from that. So we've got to navigate the different requirements, and that's one of the better ways to do it. Build it on a framework, and you could use the ISO. You could also use different frameworks. NIMITY, NIST. I think these are all good ways of building in your base controls for your privacy program that enables you to then sort of build in a marketing program that could be geographical, could be specific to markets. But ultimately, it's all going to be sort of made compliant on the back end. And we've got to have the technology to basically empower privacy by design, right? And you can only do that building it on the controls that we talked about rather than specific legislation.
Mm-hmm. By the way, is there anyone using the NIST standards as their baseline for compliance? I think that's a very interesting standard. It's developed by the American Institute for Standardization and Technology, if I recall correctly the name. And it's very interesting in that way that it lists about 100 functions and controls that you can implement. And then it says you have to choose your own profile, which means that, for example, I take A, C, and E, but not D and F, because I don't like it and I don't find this appropriate. And nevertheless, after completing this, you can say, okay, I'm like NIST compliant, but that's basically my profile. I think that's an interesting approach, and I have seen different stances on this, because some say, well, you can't just pick and choose, you have to comply with all of this, because initially it was written as a holistic approach of you have to comply with other thing. But at the same time, if we structure it as a take it or leave it, and everything has to be adapted, we exclude a certain portion of the market, like small and medium companies, which just cannot afford this. And maybe some other frameworks may be more appropriate. For example, I know the SOC 2 standard includes privacy principle. So if anyone has, from us, if anyone has this certification, if anyone is planning to, I think this would be a good segue to the next part of our discussion. Or if anyone has any thoughts on like certification as a way to structure your own compliance as vendor management, that would also be an interesting line of discussion.
I would say the certification approach works based on the industry you are in. Mm-hmm. If you are in an industry wherein you are consistently on a regular basis applying to hundreds of RFIs, RFPs, and you got to justify you are compliant with privacy. For example, you're manufacturing security cameras and you got to justify you're going to protect data, your cloud is compliant or something like that. In those cases, rather than having the debate and having to fill in the forms, which the privacy professionals would need to do it, and having a large team and filling it every time, you can say, hey, we are ISO 27701 as well as this and that and that. This is our policy. So if you have any questions, that's how it is. So you're closing the argument even before it begins, because I had the opportunity to work in a manufacturing firm which was providing security solutions, and I was the global privacy manager there. So that was the first thing we needed to do, because in a week, I would get some 25 to 30 forms which I need to fill. And every time I'm saying the same thing, but the questions are so different, it's painful. And these were the ones which were landing with me. I mean, a lot of sales people would fill it on my behalf or on their own, reading from the website. And that variety you don't want, because you want a consistent message. So then certification helps you.
Indeed. Certification, I think, is a very good approach. At the same time, it may not be fully adaptable to your particular situation, and sometimes people view it as like excessive, because why do we want this and this and this when it's not the focus of our organization? And nonetheless, you cannot skip these steps, because otherwise you will not complete the audit.
And as I said, in our case, the question was always, do you have a GDPR certification, or can you demonstrate compliance with any of the existing certification? They would mention 4 or 5, and ISO 27701 would be the usual one. Mm-hmm. And if not, please fill in this questionnaire. So you don't want to be in the if not and filling in the questionnaire, because then there are questions and back and forth. And that's where it simplifies life a lot.
Indeed. I also know from like some market chatter that Facebook is regularly sending out data protection assessment questionnaires to people using their developer platform. For example, if you're using Facebook login or their different products, they may from time to time send you out these requests. And unless you have a certified protection mechanism like ISO certification, SOC, report from the auditor, then they say, okay, so if you don't have them, then disclose whether you have 13 items of data protection mechanism implemented, like the encryption at rest, encryption in transit, and different other measures, which you then have to show evidence that you have implemented. So I think that's another important like stakeholder in our job because a lot of pressure comes from our counterparties, which at times send us questionnaires and ask us about the measures that we implement to protect data. And sometimes I feel like the level of data protection that is necessary to complete these questionnaires is quite on par with basically the legal requirements, and they serve as like a self-regulation in the market. I think that's a very valuable tool. So what's your experience with undergoing such sort of questionnaires, and maybe you send those type of questionnaires out yourself to your vendors?
I would say we do send those questionnaires as well, but regarding the Facebook one, I had a reflection. It's good Facebook is sending it to developers, but who is sending it to Facebook? Because we as individuals cannot, but I think we need somebody who has the power and the scale to send it to Facebook and say, hey, we like to have some answers on your AI data protection approach. But anyways, that was just a sidetrack and a reflection I had. So I thought we'll share it. But it's a balance. You don't want to overdo, but you want to do the right thing. So we were getting these, and I said, for our perspective, we will have this ISO 27701 certification and ISO 27001. But when we were the controller, we also wanted to make sure that our data is being protected. And we had a similar approach. So rather than saying we want to be the smartest, we learned from all our suppliers and said, what are the best practices? What are the best questions? And we created our own questionnaire based on that and said, can you do this for us? So rather than innovating and creating our own, we took the best practices, because there were a lot of best practices from some of the best companies which we were working with as we were providing security solutions.
Mm-hmm. I think it also often raises some eyebrows that, for example, in certain countries like China and Russia and other countries, we have localization requirements and the associated risks like legal and technical that come with it. So Ekaterina, how do you handle this category of questions and issues?
Yes, about when it comes to localization requirements, I believe that it is a global trend, not just in Russia, but also in other countries which would like to control personal data of their citizens by many reasons, like tax reasons, political reasons, censorship, and so on and so on. In Russia, this requirement came into force in 2015, firstly, and some global companies like Facebook, Twitter were fined, penalized, and according to this requirement, all the data controllers processing personal data of Russian citizens are now required to initially store and process the personal data in the databases located in Russia. This company still may transfer personal data to data controllers or processors located in another countries, but first of all, they need to store personal data in databases located in Russia. This requirement actually may be implemented in many different options, and my recommendation is not just draft. Is not limited by drafting agreements with hosting providers in Russia, but draft scheme of data of compliance of data localization requirements to demonstrate to Russian data protection authority that you comply with these requirements, and because Roskomnadzor now is preparing for development special technology to that would be used during the inspections to check if you really comply with this requirement. So you so drafting all the necessary documents may be not enough to comply, and it's very you need to know that there are high penalties for if you violate these requirements. When it comes to penalties in the amount of 6 million rubles, from 6 million rubles to 18 million rubles, or $250,000. And moreover, Roskomnadzor, Russian Data Protection Authority, may block internet site, may block mobile applications. We have already have such cases like LinkedIn or smart voting, which were blocked by Roskomnadzor, and also Roskomnadzor may slow down internet site and internet companies which violate these requirements. And moreover, Roskomnadzor may block, not Roskomnadzor, by direction of Roskomnadzor, payments and transfers of mobile applications, internet services may be blocked if this requirement, if the company doesn't meet with these requirements. So localization, data localization is a trend, and it makes sense to pay attention to these requirements, not just in Russia, but also in China and in other countries which in which these requirements came into force.
Right. I think, Diana, you also had your experience with localization in your country, right?
Yes, we also have a specific approach to privacy in our country, in the Republic of Moldova. So we have a law based on Directive 95. So we are in the process of, well, okay, we have a proposed draft of law based on GDPR, but it was now voted in the first reading at the parliament. But now we are dealing how to make it more GDPR approach, because there are a lot of local know-how, how I'm telling about, and that's why we are debating with our national authority in this regard, so to have a law that will be in compliance with the GDPR. But at the moment, for the controllers, for operators, there are a lot of challenges, because also we have a government decision on requirements for the assurance of personal data security in processing in the information systems of personal data, and namely is based on ISO 27,000. So for an operator that have 2 or 3 employees, it's quite tricky to be in compliance with these decisions, because it's too costly for them. This is one challenge. Another challenge is the notification. All the systems have to be notified to the authority, and the main challenge is when you are using subcontractors. For example, based on our law, we have just 2 types of roles: the controller and the processor. And we the link usually from practical point of view, there are a lot of subcontractors, but you cannot go further, because you have to notify them as a processor. And when you are dealing with big companies, for example, when you are using some clouds, for example, you are in the situation when you have to acquire from I don't know, from Microsoft to be notified at our national center in order to be in compliance with our local law. So our law is quite outdated. Even if we talk about the consent from the data subject, also there are some requirements too outdated. For example, the consent could be required only based on written consent, or maybe electronical signature. Electronical signature in our country is used about 10% of the population, so it's quite hard to be in compliance with all these requirements in our day when you are in a digitalized world, and there are a lot of tricky situations. So we are trying to go further with the GDPR. So in order to have that adequacy level, in order to make this transfer of personal data between at least with the EU countries.
Yeah, right. Igor, you want to jump in on localization or any other topic?
Yeah, I'd like to follow up on the localization requirements. Personally, I don't like this trend at all. And I think it's fragmenting the internet and complicating compliance for everybody, for global businesses. So the net is open, but now it's kind of, we have sovereign webs in larger countries, and this is difficult to accept. Secondly, it kind of personal data. Again, it's my personal opinion. It's about your choice of how your data can be handled, and a lot of legislation is talking about empowering you in how you can control the data. But in terms of localization, for me, it's kind of government is telling you how you can handle your data, trust somebody or not trust somebody, and it's kind of intrusion. We have been talking previously about big companies hijacking privacy. So localization for me is government hijacking privacy. What I would also like to highlight is there are very different underlying reasons and public interests pursued by governments implementing data localization requirements, and this should be taken into account. And basically, the workarounds companies are building are usually based on the interest, like what is the goal the government is pursuing implementing this requirement, and what is the cost of compliance from consumer trust perspective. So for some companies, I guess this is also a kind of ethical choice, whether to comply or not comply with localization requirements.
Yeah, that's precisely the word that I had in mind is ethics. So the question that quite a lot of times arose in my discussion with business is that at certain times I said, well, we comply with this not because there is a certain, not only because there is a certain probability of our behavior being revealed, and then we have to bear the burden of reputational risk and financial risk, operational risk, but because this is a human right and this is a matter of ethics. So do you use ethics as an argument in your discussion? As, for example, yes, there is a way to comply with local laws, but the local laws require us to be not honest with the consumer, for example, and, for example, implement these draconian localization measures. So ethically, I'm against going into this jurisdiction. Does this happen in your practice? Does this happen to you as a person? Do you like speak out loud these thoughts that you're having? Because privacy has impacted us a lot, and we are much molded by this legislation. So do you believe that the same should be extended to other people that you're communicating with within your organization?
I just want to add that we have an ethic and compliance officer in this regard. So is also part of team that are reporting to the top management in our company. And also, I think we should emphasize that the awareness within the company, that privacy culture should be at the highest level in order to assess each project, each plan if there is some tricky situation from privacy or ethic point of view, because when I'm dealing with these dilemmatic situations, I usually go further with the emotional part, what Christina had told to us within her presentation. What about you? Are you okay if you will be that data subject when your data will be used in different situations? Because our data is like our good. So how will you feel when your good will be used by other person? So and this question usually works well for our management in order to think once again if it's okay or not.
Right. I mean, I had a fascinating discussion, and I'm still at odds what to think about it, and namely regarding transparency. For example, say a user comes to your website, and the question is whether you have all these notification pop-ups regarding how you process their data. And my perspective is, of course, well, we have to tell them so they can make a rational, informed decision on whether to continue using the service or not. It's even not about consent where you have to check the checkbox. It's more about like being transparent, having to rely on legitimate interest, showing what the essence of the contract is that you're concluding with the user, and showing that, for example, if you insert your email here, it will only be used for authentication purposes. So for me, it's like a no-brainer. Yes, we have to disclose this type of info. At the same time, like other people who are not like a bit crazy with privacy say, well, they came us for a different reason. They wanted to use the service. They didn't want to read all this stuff about how their data is handled. If they are interested in this, they can go to the privacy policy, and then it's your job to structure the privacy policy so it's readable and it relates to different contexts that happen on the website, and people who are interested in them then can spend time reading it. But you don't have to clutter my interface in order to make it like privacy perfect. So what is your take on this? So whether we are indeed the bearers of the truth, or are we just a tug force that should be like tugging into one direction, and the product team and designer team should be tugging into the other direction, and then we come to the perfect solution?
There should be a gold balance between all of this. And also, I just want to emphasize about the external awareness, not only internal awareness about for your employees how to treat that personal data, but also as a reputation of a company that you are treating the personal data in law compliance. So that the customer could trust that this company that I have chosen is a trustable company, that I'm reliable, that all my data won't be sold to another company without my consent, and so on. So I think here the company also could work on this. For example, I don't know, to make some event, or I don't know, there are a lot of different tools and ways to make it. For example, we have some projects that dealing with this part. We are working with the children's parents, with the grannies, and between of our interaction, we also are talking about the privacy and our way of privacy. And so we are raising this awareness that, oh, by the way, there is privacy issues also, and this company is treating my data very seriously. Why not? So it's a good way of taking into account.
Right, I totally agree that your internal culture of handling data is very much reflected in how you treat your employee data. It's basically the people who work in your organization, when they see that their rights are being respected, they trust the company more. And at the same time, I think it's a very strong argument in like privacy discussions with the team is, well, if you were that user, would you be content with what happened? And I think that's a very powerful way at looking at this. And it's actually very much similar to legitimate interest assessment, because you have to show that the user expected such sort of behavior of the controller, and this is indeed the processing that's happened. And being just imagining yourself as a non-lawyer, non-privacy professional, just looking at it from the outside and trying to step into the shoes of the data subject really is indeed a very powerful and a very much empathetic act. So I honestly enjoyed the work we are doing, because it's inspiring. We are expressing love and respect for people, and I think that's beautiful. Okay, so I think we're almost done with our session. Thank you so much. Does anyone have any closing remarks, any comments regarding the discussion we had? And if no, I thank you so much. It's been a pleasure. It's been really interesting. I hope to see you at other events, at other opportunities, and I wish you all the best. Christina?
What?
Yeah.
Yes, colleagues, thank you very much. I just thinking that you maybe also add something, but was not ready to go to the affair. So, dear colleagues, what we made today is really very important, and I think that it was very useful and interesting, and I can't find appropriate words to share my emotions and my pleasure to working with you. And I think that our event today show how different people from different jurisdictions, countries with different thoughts, opinions can cooperate together and make together really good and a fantastic project which can be competitive on our market, privacy market. So thank you very much for this. And if you want, you can stay to the results of our today's session. And the format will be the follows. We just discuss our thoughts about today's second day of the Congress. Oleg, please do not leave us, because you today was the main person.
Sorry, I have a meeting in 2 minutes.
Okay, understood. Okay,
yes, thank you so much, guys. See ya.
Okay, thank you.
Pleasure. Bye-bye.
Thank you, Oleg. Thank you, everyone.
Thank you very much, Oleg. And also I want to thank you, Ekaterina, for bringing today our speakers from Miro and Wargaming, and that you really have conversation with them, and we're happy that they connected to our Congress. And now I want to share my word with you, in case maybe you can also share with us your opinion, comments, and maybe thoughts regarding today of the Congress. As I know, we have 30, 20 watching people during the day, and I think that the number is good, because our session was in English, and we hope that another audience will see our recording and broadcasting, and we also will share the recording of our today Congress Day with you for sharing with your colleagues and friends, and there will be a lot of useful materials, I know. And also we added to the our video on YouTube time tags with information about each topic, so you can navigate during these 8 hours, I think 7 hours session, and find topic which you want to watch. So thank you very much, and you really keep the audience at the same number, and it's I think quite useful and proved that your topics were very interesting, and you as a speaker are really very good. So who are you wants to speak the first and share with us opinion? Who are you wants to be first? Maybe Kate, do you want?
Yes, thank you very much, Christina. You are a great leader of this conference, of this Congress. I've been participated at many privacy conferences in Russia and in Belgium, and I should admit that this Congress is really is really great because of different speakers from different industries, business industries, and with unique background, different background. And it's very unique opportunity when the speakers can share their knowledge, thoughts, and exchange with other speakers and participants. So I will watch all the presentations in records. Anyway, all these topics are very thought-provoking. So thank you very much for the organization, and I hope that this Congress will repeat every year at least. Thanks, Christina.
Thank you very much, and we really wanted to see you at the next year to participate in our Congress, and maybe you also know in other communities and associations, just bring them to us. Now we have 25 partners on the Congress. I think that it is really a very huge number. To be honest, 1 month ago, I can't imagine that there are a lot of different communities, not IPP only. It's I just telling you about local communities. So anybody wants also to share some recommendations, thoughts, opinions regarding the Today Congress, feel free for taking the time. Just go to the air.
I think it was wonderful to be here, and I watched or listened to some of the presentations. It's always exciting and interesting to see other opinions, because that's what data protection is about. Because the law allows us, or the laws allow us to have our own opinions, interpret them, and make proposals. While at the core level, we are all aligned, but at the execution level, I see a lot of learning, a lot of ways in which we are making a difference. But more importantly, what I'm glad is you took the time and effort to organize this, have us all here, and allow us this opportunity, and even others, to learn from each other and learn from us as well for the audiences. So thank you so much. And I look forward to your next event, whenever it is, because it's well organized.
Thank you very much, Pranita, and for so kind words. So colleagues, anybody wants? And if no, we just can end our Today Congress.
I just want to say that I'm very enthusiastic to meet such a lot of people that loving privacy, that is more than just compliance issue, and it's more than just a competitive differentiator. It's a passion for privacy, and that's wonderful, especially in a digital area where privacy is must be a priority. So thank you very much for gathering us all together to make such a big event, and that was very nice. And we are truly thankful for organizing. Thank you.
Thank you very much, Diana. Thank you, colleagues.
I'd like to jump in and to say thank you so much for organizing this. I know how hard it is, and to keep everybody in time. I think this is an extra challenge when people love talking, and people have been missing each other during the pandemic. So everybody just appreciates the opportunity, I guess. what I would like to say is that it's always good to go out of your gaming cave, I don't know, banking cave, whatever cave you're in, and hear other people experience. I guess for future, it might be beneficial to have some thought-provoking, argument-provoking discussions, whether like privacy can or cannot be monetized. So we can choose some really hot topics and see some cool debates, because usually speaking publicly, people are kind of cutting edges, a little bit more careful, but with things like this, there might be some really hot discussions, which I always love. So that's my take.
Igor, I really think that it is a good point, and maybe on the third day of our Congress you can join. You also we welcome you. There will be some translator by means of YouTube. You can use YouTube subtitles. So on third day of the Congress, they will be our speakers from CIS countries, and they will challenge the local legislation, because regarding the local legislation in Eastern Europe and Asia, there are really a lot of questions. So also will be supervisory authority, and I think that for some of you, for example, Eastern Asian region is something new, and people from Kazakhstan, Kyrgyzstan, Georgia will share with us their knowledge regarding the applicable legislation. So, and also I think, yes, we will add hot topics, especially in case if you will have format, live format, not online. For next year, I really have some hope on this. And I think that in live, people are more open, and they do not afraid the recording of their speeches. So thank you very much. And in case, Darryl, yes, do you want to? I see you unmuted. So
oh, thank you, Chris. Yeah, no, I just wanted to say thank you very much and echo the sentiments of everybody on this call. It's been a fantastic experience. You've been amazing at driving us. And, you know, upwards and onwards. Next year is going to be even more exciting. So, yeah, well done.
Okay, thank you very much. And I really have a lot of experience because of you, because of you as you all guest speakers. So thank you very much. And I think that on these words, we can end our today's second session of Eurasian Data Protection Congress. And we're really happy that our second session will be really fantastic. And so keep you safe and stay in touch, and I hope that we will see together each other in live format in next year. Thank you. Bye.
Thank you.
Thank you. Bye-bye.
Bye.
Thank you. Bye.